Good afternoon. This is the matter of Action for Freedom versus the Minister of Health. Came before me as an urgent 2 weeks ago. Case number is 85/2022. Can I just check if Mr. Pillay and Mr. Sabandla has been able to join us?
Lady, I saw Mr. Sibande in the waiting room at some point, so I would have thought he had been admitted. Oh, I see he's waiting to be let in. Let me let him in if I may.
Thank you, Mr. Budlander. I'm also going to request in the meantime those that people who are not, or observers who are not counsel, who are not addressing me in this matter, that they please put off their cameras. And that they mute themselves. There are a lot of people who are party to this link, and if everybody has their cameras on, I'm afraid it might affect the strength of the link. Mr. Budlander, have you admitted Mr. Sabandla?
I have, my lady, although it appears in the lobby that it still says being admitted or admitting, which might suggest a problem. Perhaps I could ask my junior, Ms. Mayosi. I don't know if she has Mr. Sibanda's number. Perhaps she could just give him a ring and check what the position is.
I'd appreciate that. Thank you.
Namisa,
Yeah,
can you...
I do have his number. I will check on him telephonically.
Thank you. Shall I then mute myself and put the camera off until such time that everybody's able to join us?
Yes, thank you, my lady.
Yes.
Perhaps Mr. Ronnie Naidu could turn off his camera, which is currently on.
Hey, good afternoon, everyone. Obviously, the hearing will be starting any moment. I can see they're just fixing a few logistics there, but we will tune straight in.
Yes. So he's waiting in the lobby, and he's battling to be let in.
But every time I try and let him in, it just sort of
It says
hangs.
the action failed. I also tried that. So perhaps Ms. Khumalo should try to let him in as the host. Yes, Judge?
Ms. Khumalo has been trying to let him in. Similar problems. It might be that there's too many people connected. I see there's over 102 people joined to this link. This link is not made for that many people to join. So unless a few guests leave, Mr. Sibanda may not be able to join. Let's see, I'll try and liaise again with Ms. Khumalo to see if she's able to let him in.
Misa, have you got Mr. Sibanda's number? Won't you let me have it?
Hi, Stephen. I'll give you Mr. Pile's number. They are together. I'll give it to you now.
Thank you.
Okay, I've been told that there are too many people on this link and there's not enough room to allow Mr. Sibanda in. So unless some people who are not party to this matter leaves the link, Mr. Sibanda is not going to be able to join. And then there's a Mr. Mobodla. Can you please put off your camera, sir? Thank you. So Mr. Sibanda is not going to be allowed to join because the matter's reached capacity. I see some people have left now. We'll try to admit him at this stage.
Is that Mr. Pile's device that is now joined?
Hello, is that Mr. Pile's device that's joined? Is Mr. Pile joined in these proceedings?
Judge, when I spoke to Mr. Pile, he had indicated that they were trying a second device, and I presume that's the one that's just come up. So perhaps you could just allow him a minute to see whether that solves the problem.
Okay.
Mr. Pile says that is his device. He was just out of the courtroom, but is stepping back inside now.
Okay, and people in the courtroom, it's still a courtroom. No cameras are allowed, and you can't take photos of proceedings unless you have permission. If people are not going to adhere to the rules and decorum, I'm going to have them removed from the courtroom. There's a lady in the courtroom who continuously takes pictures on her cell phone. Can she please put her phone down, or I will have her removed from the courtroom?
Milady, might I address you with your leave, milady?
Good day. I assume you are Mr. Willis.
Indeed, sir, my lady. I just thought it opportune to introduce myself to you. Thank you.
Good day, Mr. Willis.
Ladyship, please.
Okay. Is Mr. Pillay going to be in court anytime soon?
Let me try and phone him again, my lady.
Thank you, Mr. Budlander. Mr. Pillay, are you able to join us?
I have a feeling that their sound might not be on. I don't know if they can hear us, my lady.
Oh, okay.
Let me just phone him back again.
He's on mute, Mr. Budlander. It seems he's on mute.
Okay, maybe they're busy sorting it out. Let's hope that that resolves the difficulty.
Right, everyone. As you can see, these are the court proceedings. So they're just busy sorting out a few logistics. As we can see, everybody's in court. That's the judge, Judge Slingers right there, and Nas Sabello and
Good afternoon,
Nevan,
Good afternoon,
our
Mr.
legal
Sibanda. How are
representation.
you?
So
Very
we'll
good,
just
thank you, Judge.
leave this to everybody else.
Apologies, we seem to be having some technical issues, but I think we're now okay.
Thank you. Then, Mr. Sibanda, you with Mr. Pillay. I've seen Mr. Budlander and Ms. Mayosi. Also seen Mr. Willis. And as I've indicated, just for record purposes, yesterday I've called in Mr. Pillay as well as Ms. Lombard to explain to them that I had at that stage received an indication of an application to join as a party to these proceedings, and I have a half-hearted application as an amicus. Since then, I've received another application as an amicus. I've explained to both Mr. Pillay and Ms. Lombard that before the matter can proceed on the merits, those applications will have to be considered and will have to be dealt with. So just for record purposes, I've got an application to intervene by the ACDP, who I think are represented by Mr. Willis and Mr. Monzinger. Then I've got an application to intervene by my individual right to be informed. I don't know if anybody is on this link representing that particular applicant. Could I just ascertain, is my individual right to be informed, my individual right to informed consent, is there anybody here?
Yes, that's Teresa Schroeder. I'm here.
Okay, and then I've got an application to intervene, or rather not an application, I've got an affidavit by Indigenous First Nation Advocacy, IFNASA. Is there anybody here from IFNASA?
Sorry, Judge. Sean McDonald did call me. I think they were they were on the way. I think they just got slightly delayed.
Do I need to stand proceedings down? Is he able to link? What is his position?
If I could just, I'm not sure. where he is right now. I think they were trying to rectify their papers and make more copies or something.
Well, if they're not formally a party to these proceedings, they was given the link. If they've not joined, I'm not going to hold up proceedings. We are going to then proceed. Mr. Pillay and Mr. Sibanda, or rather Mr. Sibanda, perhaps you can advise the court what is your position pertaining to, at this stage, the application to join either as an amicus or as a party to these proceedings.
Your Ladyship, thank you very much. We have no objection to any of the parties that have indicated an interest to join the proceedings.
Thank you. Let me hear from Mr. Badlander.
Thank you, my lady. Could I deal with each of the applications in turn?
Yes.
If I could deal with the African Christian Democratic Party first. Their application, my lady, is somewhat confusing. If the intention, and I'm sure my learned friend Mr. Willis will clarify it, if their intention is merely to seek an order in terms of prayer 2, which is that they want leave to intervene only as an amicus curiae and only to make written and oral submissions, then, my lady, our instinct is that your ladyship should allow them to make legal submissions and admit them as an amicus so we can get the show on the road. On the strict understanding that they have not been granted permission to adduce evidence, your ladyship will know that the position is that an amicus can sometimes, I see someone is now, perhaps we could just ask everyone to turn off their cameras.
Yes, I've asked that earlier.
You certainly have, my lady.
Those who are not addressing me, can you please turn off your cameras? Otherwise, I'm not going to allow you access to this hearing.
So, my lady, your ladyship will know that the ordinary rule is that an amicus is not entitled to adduce evidence, and that an amicus that wishes to adduce evidence must specifically seek that permission in order to do that. And that is not the case. Your ladyship will see in prayer 2, it's simply an order seeking admission as an amicus. If that is the only order that is sought, then we propose that your ladyship grant that, allow them to make legal submissions, and we can get the show on the road. We do say that prayer 3, where they seek to intervene as a party, is without any basis, and we would oppose it. So we would submit, my lady, that your ladyship should grant prayer 2, subject to the fact that they will not then be permitted to introduce any evidence as part of their affidavit. It's simply for purposes of making submissions. And that's the relief that they've sought.
Mm-hmm.
Then, my lady, that deals with the ACDP. And then what remains is the application by my individual right to informed consent. Now, my lady, with great respect, that is an application, it seems, for intervention in terms of Rule 12. It is wholly prejudicial because it came over the weekend. My client has not had an opportunity to deal with it, and we would ask that your ladyship dismiss that application, and we do not seek an order as to costs. And then there is the Indigenous First Nation, but that has not been moved in front of your ladyship, and I therefore do not intend to address it further at this stage.
Thank you. May I hear from Mr. Willis?
Thank you, my lady.
Mr. Willis.
As your ladyship pleases, my lady, thank you. The position for the ACDP is that we did indeed initially seek to be admitted as amicus. Unfortunately, in the rush of putting those papers together, we did forget that second prayer, Mr. Button. It's not prayed. What one would read in the papers in our founding affidavit, we make the point that we won't be going outside of what's in our papers, and that by implication is that as amicus we do require that our application papers be made part of the record. And I think Mr. Bundler, as I understand him, Mr. Budlander objects to that. In those circumstances, my lady, we prefer that your ladyship does admit us as a party. Mr. Budlander has submitted to you that there's no basis for that. My lady, in the 5 sets of argument that we furnished your ladyship with at or about lunchtime, I don't think your ladyship had an opportunity to deal with that. We did point out the authority on which we would rely. In fact, Milady, one of the difficulty that I personally have had with the papers, and we do draw that to your ladyship's attention right up front in paragraph 1 of our concise heads of argument.
Which I've not seen, Mr. Willis. Mr. Willis, I've not had sight of your heads.
And my lady, I should add, my lady, I have not had sight of them either. This is the first I hear of them. They have not been sent to me.
Thank you, Mr. Budlander. Mr. Willis.
Milady, yes, I wasn't aware of Mr. Budlander being in the matter, but it was sent to his attorney. My junior did send to the other side, so to speak. Anyway, the point is, Milady, that we did allude to National Treasury with its opposition to urban tolling. And the difficulty is that we're probably too close to the bone. We do make submissions in these heads when you get to see them that we say, notwithstanding our position and our interest and our constituency and what would be otherwise a legal interest, we still submit that we could be admitted as amicus. But, Milady, we prefer to be joined as a party. We submit that on our affidavit that your ladyship would have read. There's nothing new. It's merely legal argument. There's no real evidence of any substance there that prejudices the minister, Milady. So we would prefer, we think it's proper, my learned friend and I'm a singer, that it's preferable and we should opt for a joinder as a second applicant.
The concern that I have with that, Mr. Willis, is if you joined as a second applicant, in fairness to the respondent, they must be allowed an opportunity to address your founding affidavit, which means that before the merits of this matter can be entertained, these proceedings are going to have to be postponed to afford them a reasonable opportunity to do so. Now, if you admit it simply for the purposes of making legal argument, I could possibly do that in the sense that there's not going to be a delay. But if you admit it as a party, they must be given an opportunity to deal with your founding affidavit.
Lady, might I submit? I appreciate that difficulty, and that's why I've made the submission that we don't believe it needs an answer, but that's not my decision. That would obviously be Mr. Budlander and his client's position and decision. And this, of course, your lady firmly saw it from our point of view. Might I say this, Milady? In our affidavit, we make out our grounds to be joined and what our interest is, etc. There are certain submissions made therein which don't need an affidavit to make them. And then there are components which certainly Mr. Budlander would highlight is definitely evidence. We don't want to hold up the proceedings at all. What I would then suggest, Milady, is that we be permitted to argue off the case we put up in our affidavit. So we'd be admitted as a second applicant, but we'd be permitted to argue off that case what we have raised. So, for example, Milady, the principal case for the ACDP is not the same as that for Action for Freedom. Their case, as I see it, Milady, is a rather narrow, crisp point around the interpretation of Section 90 sub 4 sub C. And that's, I think they framed their case in and around that. We say something different, Milady. We would say that under Section 6 of PAJA, the minister's decision falls, he says, aside. It doesn't pass muster, and we've raised and alluded to that clearly in that affidavit. But I don't think we need any other evidence to argue that than the minister's own reasons. And, Milady, in those circumstances, if we could craft some sort of a qualification as to the admission of that affidavit in a way that does that no evidence will be relied on, such as evidence which the minister would otherwise want to answer to, Milady. That way we cure it, we'll make our submissions. We believe we can make that case out on the minister's own papers, Milady.
Thank you. Mr. Sibanda, you have indicated you've got no objection to any of the parties joining. Therefore, I'm going to ask Mr. Budlander to reply to the address by Mr. Willis. Mr. Budlander.
Thank you, my lady. My lady, let me first get out of the way the question of whether they could be admitted as an amicus, I beg your pardon, as an intervening party. With respect, your ladyship is correct. if they were to be admitted as an intervening party, as a second applicant, we would be entitled and indeed obliged to answer, and that would mean it cannot proceed. And we object on that basis alone, and we ask that if, insofar as they persist in that, the application falls to be dismissed. Now, if they want to come in as an amicus, my lady, I have drawn your ladyship's attention to the ordinary principle, which is that an amicus is limited to the record before the court. That appears, my lady, from the decision of the Constitutional Court, which I will give you now. That appears from the decision of the Constitutional Court in the Children's Institute case. That is Children's Institute versus the presiding officer of the Children's Court, 2013 2 SA 620, a decision of the Constitutional Court. Now, in that court, the Constitutional Court held that an amicus could seek permission to adduce evidence in the High Court, but that it should do so formally and squarely, and that everyone should be given a chance to answer it. That has not happened in this case. And although my learned friend, Mr. Willis, makes out as though he just left out a prayer in the notice of motion, that is not correct. The affidavit itself does not seek leave to adduce evidence. So insofar as there's an effort to rely on new evidence, it's not properly before your ladyship, and we would ask that it be disregarded. So I repeat, we have no difficulty with prayer 2 being granted, subject to the usual rule about evidence. That leaves the last question, and that is that it appears that my learned friend, Mr. Willis, now seeks not merely to make submissions, but to advance a new cause of action. We object to that, my lady. An amicus is not ordinarily allowed to make a new cause of action. An amicus is required to make submissions that are of assistance to the court, but is not meant to make a new cause of action. And the problem caused by it is demonstrated by this case. My learned friend, Mr. Willis, now wants to raise for the first time Pudger. He wants to raise Pudger in circumstances where we're not prepared on Pudger, where nobody's pleaded it apart from him as an amicus, and where there is no Rule 53 record. And he wants to raise it in circumstances where Pudger is inapplicable, because the Pudger review will come at the end of the day. Now, I don't want to argue this now, my lady, because it seems that it will trespass on some of the merits, but I simply wish to record our concession that Mr. Willis's client should be allowed to be granted amicus curiae status is not a concession that his arguments are properly before you. We will deal with them insofar as necessary during the course of the address. But we submit that with respect, the attempt to now change the case fundamentally is not the role of an amicus, and it's particularly not the role of the amicus in urgent proceedings where we've been under enormous pressure to respond to the main case. And we will argue that your ladyship should not decide those. And if the African Christian Democratic Party wants to go and run its own case separately on Pudger, it can do so in the fullness of time. But it seems to us, with respect, your ladyship doesn't need to decide that now. Your ladyship can decide that when hearing the main argument.
Thank you, Mr. Padlander. Mr. Willis?
Yes, thank you, my lady.
Generally, you're not given an opportunity to reply. That is the... But you are the applicant for intervening, so you will be given a very brief opportunity. Yes. Otherwise, we're not going to get to the heart of this matter.
Absolutely, my lady. I seek it as an applicant, not as... I should have gone first, but that's fine, my lady. Lady, Mr. Badlander's submissions are correct, save that he simply has failed to put the emphasis on what I placed before your ladyship. We don't seek to join as amicus. I argued to your ladyship to join us as a second party, but to qualify our position so that there's no prejudice to the Minister and Mr. Badlander in relation to evidence. Now, Mr. Badlander, however, has raised another objection, what he calls a second cause of action. He's not incorrect on that to a degree, but, my lady, we have put forward that in fact is what the applicant's case is an administrative attack or a Pudger attack. That's where the ultra vires falls in. But we merely expand on that, my lady, to say that the decision is falls to be set aside for other reasons too. My lady, I can't dispute that there is more to it now than there was before our paper. But if your ladyship is going to make a finding in relation to the Pudger grounds, well then, my lady, we would nonetheless ask that you admit us as an amicus And of course, we would then stay within the rules of an amici, of course, and make the submissions and be of assistance to the court to the extent that we can. But, milady, we do nonetheless ask that you admit us as a second applicant. I cannot rely on evidence, but that your ladyship allow us nonetheless to rely on the extended argument. My learned friend, milady, is more than adept at handling and dealing with that argument, milady. The minister, the fact that the minister hasn't seen it, milady, or they have, well, I don't know which part of our papers they did or didn't see. Milady shouldn't stand in the way of proper decision made in this matter. Matter of grave importance, milady. You can see the interest in the court. Thank you, milady.
Thank you, Mr. Willis. I'm going to deal with each application as it comes. Otherwise, there's going to be confusion. I'll deal with the application of the ACDP to join before I deal with my right to informed consent application, because I must still engage Ms. I think Schroeder in respect of that matter.
Excuse me, Your Ladyship, if I could interject very well.
Yes, Mr. Pillay. Sorry, Mr. Sibanda.
Okay, Your Ladyship. I've got next to me Mr. McDonald from IFNASA. I think he's...
No, Mr. Sibanda. He must wait till I'm ready to address him. He was not here when the matter proceeded. He was given the link. This might be a hybrid hearing, and we might be assisting people by forwarding the link to them. But we are going to maintain some court decorum and some court etiquette.
No, the thing is,
Mr. McDonald can't just come and speak when he wants to.
No, Your Ladyship, I was just bringing to your attention the fact that when the proceedings started, the IFNASA was not represented at the time at which they were called. So I was just highlighting to the attention of the court that Mr. McDonald is here. And one of the things that he has indicated is that their representative is now online, who was having difficulties connecting, just so that when the court is dispensing with the matters that are already before it, the court is aware of the fact that IFNASA, who was called earlier, is now online. Thank you, Your Ladyship.
Thank you, Mr. Sibanda. I understand the argument by the ACDP that they want to be adjoined as an applicant rather than an amicus, and I can understand the basis for that, given their political affiliation and the judicial, or rather the precedent on which, not the precedent, the case on which they relied, that set out basically that given the political agenda of a party, that such parties best be joined as applicants. While Mr. Willis argued that it's not necessary for the respondent to be given an opportunity to answer to the affidavit, and they may be able to present argument based on the legal basis set out in the affidavit, that is not a decision for him to make. The respondent must be given an opportunity and an election to provide an answer to that affidavit should they be joined as a party. Therefore, I am refusing the ACDP at this stage an application to join as a party as a second applicant to this matter. Should the ACDP wish to make legal submissions based on the relief set out in the notice of motion of action of the applicant, Action for Freedom, then it may do so, but it will be limited to the relief as set out in the application of Action for Freedom. While he may present legal argument pertaining to the proper cause of action, he may not introduce legal argument pertaining to the review of the decision, because that is not what is being requested in the main application. So the application to join as an applicant is refused. However, the ACDP will be allowed to make legal submissions pertaining to the relief as set out in the main application of Action for Freedom. I trust that position is clear, Mr. Willis, Mr. Budlander, and Mr. Sibanda.
It is. Thank you, my lady, as the court pleases.
Thank you, Milady. Might I just seek clarification? You're effectively allowing us to make submissions as an amicus, and we will stay within those rules, as your ladyship pleases. Thank you.
Yes, Mr. Willis. Just given the urgency of the matter, given the late filing of the application, given the interest in the matter, if you were joined as an applicant, I think it would prejudice all concerned because the respondent would not be allowed to be in a position at this stage to answer to the affidavit, and the proceedings would have to be adjourned, thereby prejudicing all the parties to this particular application.
We fully appreciate. We thank you, Milady. We've had to learn a lot as we've sort of come into the matter. We were in the dark, and Milady, we abide your decision. Thank you, Milady.
Thank you, Mr.
The court has just allowed the ACDP to make
to
submissions as a friend of the court, as an amicus curiae. Okay, so that's very good news.
Mr. Sibanda?
So now the court is going to deal with the next application. My individual right to informed consent, they are now going to make their bid to be admitted as a party or as an amicus curiae in the case. So let's just follow that.
My individual right to informed consent. The respondent is opposing her application. She may now address me as to why she should be allowed to join and why her submissions will be further or different to the submissions made by the applicant in this matter.
Thank you, Your Ladyship. I did email on Friday evening, only late, unfortunately. I did receive a reply from Ms. Lombard yesterday afternoon at around 17:49. Although I've submitted Friday, I do request that it gets allowed. There's 2 additional ones that is benefit to the public, and that I've got proof of that they need time to actually access. That government has only done 1 section of it and not allowed another section of the public to access to put in comments for the important health act that they're trying to do.
I'm not quite sure I understand your submissions. Sorry, I've just been handed another service document by the African Christian Democratic Party, but I've dealt with the application. Ms. Schroeder, I'm not quite sure I understand your submissions. What you say you've got 2 important points that's not being covered. Can you please set out what those points are?
I would not say it's not covered. It's just a platform that government uses with certain information that they do provide to the public for free. But the one for comment, they've not allowed free public participation on that one. And that is a very important part of being informed of what their rights are to comment on this act.
So do you have anything to contribute to the debate about the time period within which the regulations or comment to the regulations were set out? What is that?
That there was no 30 days is not allowed, and that the public was not given the opportunity to provide their comments on a free platform as that the government has on the vaccination registration, as well as the Vax Euro platform, as well as the coronavirus, and then on a separate, the Constitution. The government provided that for free for access for the public, but they have not the comments on this important change that's now 30 days instead of 90.
Ms. Schroeder, I see that there are 3 directives to the applicant. Where do I see permission for you to bring this application on their behalf or on behalf of the applicant? In the papers which you filed with me?
Yes, it's in a resolution.
I don't have the resolution in front of me. I do not have the resolution in front of me, Ms. Schroeder.
Okay, what must
it's not attached to your papers.
It's Annexure TAS 1.
That may be, but it's not part of my papers.
I sent it through on the email. My apology for that. I can bring it up quickly.
No, Ms. Schroeder, this is an urgent application. We deal with the matters as they are. I do not have the resolution in front of me.
In the email, my apology for that, Your Ladyship.
Now, Ms. Schroeder, how will extending the time period assist you? Because you're not asking for further relief that the regulations be provided on a free platform, or rather that comments be provided on a free platform.
Yes, we are asking that, and it should be the longer period because the public needs to be aware that they've got this option that they can do it for free, which is currently not free.
Okay. Ms. Schroeder, when did you find out about this matter, about these papers, or rather about this application?
On Thursday.
How did you find out about it?
Within the Telegram and WhatsApp groups that I belong to.
Okay. Were you not then informed via the Telegram and the WhatsApp groups of the application itself being instituted?
No, I was not aware of that. I've been away for a while, and when I've caught up on everything, that's what I saw.
Okay. Was the notice of this application set out on the Telegram and the WhatsApp groups you belong to?
The notice itself, no, just the detail that there was a court case.
And when was the details first published on those WhatsApp groups?
Probably, I can't recall the date. When I viewed it was Thursday or Wednesday evening, Thursday morning. That's when I would have seen it.
Okay. Is there anything else you'd like to bring to my attention?
Your Ladyship, it's just the fact that we are speaking on behalf of the public that requires different languages and a free platform for them to actually partake in the comment section as they were provided for the registration of vaccination, Vax Heroes, coronavirus information, and providing the constitution on free platform.
Okay, I just also want to place on record that the application or the notice of motion was only brought to the court during lunchtime after 1. I've not had an opportunity to consider it, to properly go through it, given the shortness with which it was actually brought to me. That being said, Mr. Budlinger.
Thank you, my lady. My lady, we do oppose the application for intervention, and we do so on inter alia the following bases. Firstly, it is grossly prejudicial to my client because this was sent over the weekend, and it raises different factual considerations, as you heard from Ms. Schroeder, about the ability to access websites and the relative ability to access it for free relative to the vaccination sites. We simply haven't.
He seems to be more concerned about prejudice to the minister. What about prejudice to the public? That is what we should be concerning ourselves mostly.
I'll come back to this point in the merits. But
this shows you the contempt that is being had for the public.
Comment has been inadequate because there's been insufficient time or access to free data, then that will be a ground to set aside whatever regulations are made, if any regulations are made. So there is no urgency in that sense for Ms. Schroeder or her organization to approach the court now. Thirdly, the difficulty that Ms. Schroeder faces with respect is this. Her case is factually different, but it's legally the same in the sense that she says it shouldn't have been 30 days, it should have been 90 days. But this court retains a discretion, even in the case of intervening parties, to refuse interventions where they will not materially assist the court. Could I give your ladyship authority for that proposition? It is the judgment of Gorey versus Culver. Gorey versus Culver, 2007, 4 SA 97 CC. And it's a judgment of the Constitutional Court which said, when allowing in an intervention in a public law case like this, that was a challenge to a statute, the court has an overriding power to grant or refuse intervention in the interests of justice. And the factors that would weigh include the stage of proceedings where the application is brought, the attitude of the application to the application of the other parties, and the questions of whether the submissions seek to advance substantially new contentions which may assist the court. Now, if the main party is right that the minister had no power, then Ms. Schroeder's submissions don't change the case at all. If the main party is right, is wrong, and the minister did have the power, then Ms. Schroeder's case can't, brought in this way, change the case either. So we submit this will not assist the court, and the application should be refused.
Thank you. Ms. Schroeder?
We do not seek an order for costs.
Thank you, Mr. Budlinder. Ms. Schroeder, do you have any reply?
This is just a standard response from the government lawyers.
No,
they will oppose
right
anything.
For people out there
so don't be concerned.
They need the time and they need a data-free option to be able to comment.
Now, Ms. Schroeder, I've got two options available to me, and I'm engaging you in this way because I understand and I appreciate you are a layperson. If I allow you to be admitted, as Mr. Budlander said, your application raises new facts. They then must be given an opportunity to address those facts. And in giving them an opportunity to address those facts, the entire application is going to be postponed. That's one option. Option two is I refuse your application to intervene because the legal basis on which you are challenging the regulations are very, very similar to that of the applicant Action for Freedom, in that you are saying that the time period within which to comment on the draft regulations are too short and it should be longer. So I just want to ascertain whether you understand those two options.
Mm-hmm.
Would you have this matter postponed in order to allow the respondent to answer your factual allegations? Which means that this entire application does not go ahead today because they must be given an opportunity to answer your factual allegations, which they've not had an opportunity to do.
I don't want this postponed. They had yesterday to look at it. They have replied to me on it. So there was a time that I don't want this case to be postponed due to Marieke joining.
Well, in the circumstances then, Ms. Schroeder, I am going to dismiss the application because I don't think it would be in the interest of any of the parties to delay the matter. I hear what you are saying about the respondent having some time to respond to your application, but it was served on them over the weekend. They effectively had less than 24 hours to deal with the factual allegations, and they'd have to then consult with their client, they'd have to consult with the attorney, and they'd have to consult with the counsel and draft a formal response thereto. That is just not sufficient time. So in the interest of justice and in order to finalize the main matter, and in light of the fact that the challenge that you bring is to the time period which is not substantially different to that of Action for Freedom, I'm going to dismiss your application to intervene. You are, however, welcome to observe the proceedings and to consult with Mr. Pillay and Mr. Sibanda, and I'm sure that they would make any legal submissions on your behalf, what they can insofar as it furthers their case.
Thank you very much. As the court please, Your Ladyship.
Thank you, Ms. Schroeder. Then Mr. Sibanda and Mr. Pillay, I understand Mr. McDonald is present.
So basically,
perhaps he
Marieke
can
will
then
not be
address me on
allowed
his
to make
application to
submissions
intervene.
to the court. And as she rightfully and gracefully steps down, as she says, she doesn't want for this case matter to be delayed.
Good afternoon, Mr.
NASA's turn.
McDonald.
Our CEO will be representing us in this matter. He is online.
Who is that?
Mr. Anthony Williams.
Mr. Anthony Williams. Okay. Perhaps if I can then hear from Mr. Anthony Williams to address me on the application of the First Nation Advocacy of South Africa and the application to join.
Thank you.
Thank you, Your Ladyship.
Thank you, Mr. Williams.
We would like to apologize. We struggled extremely for the first 15 minutes just to get online. It's just been a nightmare today. So we plead your forgiveness. If we could get straight into the matter, Your Ladyship, it's we feel as the indigenous First Nation people a little bit intimidated with what has just transpired. If we consider carefully the considerations and the judgments that Your Ladyship has just passed now, as far as the ACDP is concerned, and the other amicus applicant, as the Indigenous First People, we almost feel a little bit overwhelmed now, because it almost sounds like we are left outside in the cold, because we, like the others, also have submitted our notion of motion, a notice of motion very recently, and literally just before this court sat down.
Mr. Williams, before you go
yes.
further, I do not have your notice of motion. In fact, what I've got dated 22 April is a notice of application.
Judge, you've gone on to mute.
Yeah, we seem to have a difficult. Okay, the judge is on
Thank
mute.
you. Sorry.
Okay.
Must have muted by mistake. Mr. Williams, before you go further, as I indicated, the notice of application admission as an amicus curiae, which I've got dated 22 April, merely contains an affidavit. There is no notice of motion before me. I've not seen a notice of motion.
And that's exactly what I'm speaking to your ladyship. That I've just said now. It's literally a minute or so before this court was sitting that we managed to get ours in, and so I'm not too sure if I should continue.
Well, it depends, Mr. Williams. First of all, you're going to have to explain to me how it came that I got an affidavit, but the notice of motion wasn't able to be done. The notice of application, the affidavit, was drafted some time back. It was drafted on the 19th of April, or the decision to join this matter as an amicus was taken on the 19th of April. The affidavit in support of the application is dated 22 April, yet there's no application itself, no notice of motion. That needs to be explained.
Yeah, no, absolutely. Until yesterday, Your Worship, we had a legal counsel that was going to represent us, but was just too scared because of time constraints that he could not commit fully. And until yesterday, that's when we heard that he is not going to appear on record on our behalf. And we as lay people with absolutely no experience had to struggle right through the evening to put the notice of motion together, because we wanted to honor the desire of a voice by many of the Indigenous First Nation people. And
Mr. Williams, let me stop you there. First of all, if I look at the notice of application, the affidavit, this was drafted by somebody with some legal experience. The affidavit itself could not be drafted without a notice of motion, because the affidavit speaks to the notice of motion and the relief that is being sought. So it still doesn't explain why the notice of motion was done after the application or the affidavit was drafted.
Your ladyship, I'm going to accept that as a compliment. The fact that you could say that it was drafted by a legal, competent person.
No, that is not what I said. I said it was drafted by somebody with some legal experience. I did not say a legally competent person.
I hear you, your ladyship. I am just saying, I'm taking it as an absolute compliment that someone like myself and the team with absolutely no legal experience, nothing, that we managed to stumble and struggle upon, upon case law, and that's how we drafted this, including the notice of motion. Absolutely no prior legal experience, nothing. So I'm not sure, should I continue, Your Ladyship, to speak about the distinctive offering to the Honourable Court?
Mr. Williams, I'm going to allow you the same choice that I've given Ms. Schroeder as a layperson. If I allow you and I allow this application in, I've got to allow the respondent an opportunity to respond thereto, which will result in this application not going ahead on the merits and being postponed. However, I note that Mr. MacDonald is sitting alongside Mr. Sibanda and Mr. Pillay. And if there are legal submissions to be made, legal, not factual, I'm sure that could be conveyed. And I'm happy for Mr. MacDonald to liaise with Mr. Sibanda and Mr. Pillay in that regard to confirm or to clarify that position. But if I admit you as an amicus at this stage, I'm going to have to allow the respondent a reasonable opportunity to deal with it. Now, you might have served your affidavit, but the affidavit itself speaks to the relief, but the actual relief is set out in the notice of motion, which I have not got. And while I'm willing to accommodate and bend over to not strictly enforce the rules, I can't ignore a party's right to be heard. In fact, that is why this matter was postponed from the first day when it was heard, in order to allow everybody an opportunity to be heard. So if I allow you to join, I'm going to have to allow the respondent an opportunity to respond. So it's your choice at this stage whether you want to address me further on your application. And then I will make a decision, as I've done with my right to an informed consent, as well as the ACDP.
Your Ladyship, as I started out, I said that, and with respect, I thought that we are overwhelmed. And when we heard the previous judgments that you have passed, we were all, it was almost a foregone conclusion that we are going to suffer the same fate, and we say this with respect because we fully understand the context and what you've heard. I would stand at this point, and I would accept the invitation that you made for Mr. MacDonald to confer and also to confer with legal advice. We will withstand at this point.
I'm sorry, Mr. Williams. There are some people whose mics have not been muted, and they are speaking, and it's causing a disturbance. So if I could please ask those parties who are not addressing me to put their mics on mute, because when they speak,
so at this point in time, the court is considering the application of IFNASA, whether they should be allowed to make submissions to the court, whether as amicus curiae, highly unlikely.
Mr. Williams, what I'm going to do, I'm going to leave, or rather I'm going to put my camera off and my microphone off for 2 minutes for Mr. MacDonald to speak to Mr. Sibanda and Mr. Pillay, Mr. Pillay, to confer whether or not they would be able to speak to him, or rather make further legal submissions on his behalf after speaking with him. However, I stress that would be legal submissions, it would not be factual submissions. You understand?
Yeah. Yes, we do, Your Worship.
However, you have an election. If you want to proceed, you may proceed. Mr. Budlander will then have the right to answer, and you will have the right to reply in your address to me.
Okay. I would offer Mr. MacDonald the opportunity to address Mr. Pillay and Mr. Sibanda. Thank you, Your Worship. We will stand down.
Okay. I'm going to switch my microphone and my camera off for 2 minutes. I just want to see what's the time.
Okay, so that's just going to be a brief adjournment.
It's now 15:29. I will put it back on at 15:35. Thank you.
Thank you.
Okay, so that's a brief adjournment from the court, just to allow Mr. MacDonald, one of the leaders of IFNASA, to consult with counsel to determine whether there's any legal submissions that they want to make. Obviously, I can't be giving any live feed on the actual advice that they would be giving. I might just send them a message to let them know that they should turn off their mics, otherwise the whole public can hear what their deliberations are. So just permit me, well, I actually send them, because that should be a private conversation. Let me just say, turn off your mics. Okay, I think they might have done that now. That's good. Okay, so this is just a brief adjournment. So what has happened so far is the ACDP made an application to be admitted to be parties in party to the case, but according to the judge, that it's normal that if a party makes an application and they submit an affidavit, then the other party should be allowed to answer to that affidavit. And as the state's attorneys or their counsel holds, is that they would need time, and they haven't had time, according to them, to respond to it. But then again, you know, it's an entirely different question on its own as to, you know, you think the state has all the resources. They have limitless resources. They have all the money. They can employ people quite at short notice and as many as they can. But anyhow, that aside, what the court had then permitted for the ACDP to do is to be what they call amicus curiae. These are friends of the court, so they could make some legal submissions or points of law for the court to consider when considering or deliberating on the case that is before the court today. So that's what they would be doing, and reminding the court about legal elements and points of law that the court must be considering. MIRIC, unfortunately, the court had decided not to admit them on the grounds that MIRIC was not actually bringing anything new to the case. That's the court's summation on the basis of the submissions that MIRIC made. And for that reason, the court said that if they wanted to be a co-applicant in this case, then again, their submission, which is their affidavit, given that it had come in late, but obviously, as she explained, that she only came to know about the case matter quite late, that there was a risk of the case being delayed. That's what the judge suggested, because the state would have the right of reply, because they can't just deal with it there and then on the day. But two comments to that. Interesting enough is that actually there was a situation, if you recall, on the 14th, when we turned up in court, that was the first time that we got to see the answering affidavit of the state. So they didn't give it to us beforehand. They actually claimed in their own affidavit that they hadn't seen the case. The state attorney claimed that the papers only arrived on her desk on the 13th of April. Okay? And she had very little time, couldn't get hold of the minister and all of that. But checking the state's papers, it can't be true that they only received it on their desk on the 13th, because they signed a notice to oppose on the 12th. So surely they must have known about the case. And we have submitted the papers to them on the 8th already. So that's just another bit of juicy bits for you to see how the government actually responds or treats matters which are of interest and importance to the public. Again, you hear the same manner of response. You could see the same manner of response when we sent an email to the minister. We got no reply. Also sent a letter. We got no acknowledgement or reply. Okay, well, the judge is back. So leave it to that.
an opportunity to consult with Mr. Sibanda and Mr. Pillay?
We have your ladyship, but we have run into a bit of a problem. So we would have to accept that our fate today, that we would not be able to continue with the case.
So do I understand you then, Mr. Williams, to be withdrawing your application?
Yes, we will be withdrawing our application.
Okay. Thank you, Mr. Williams. You are, however, as I indicated to Ms. Schroeder, welcome to observe the proceedings, but I would request that you mute your mic and mute your camera or put your camera off in order that it not cause a distortion of the connection. But you are more than welcome to observe the proceedings.
Thank you, Your Worship.
Thank you.
Okay, so if NASA is
Then
gracefully
Mr.
standing down to
Sibanda.
allow the proceedings to continue.
Mr. Sibanda?
Yes, Your Ladyship, I can hear you.
Yes. Then it seems as if we are ready to proceed with the merits of the matter.
Indeed, Your Ladyship, I believe we are.
Yes. And you may proceed. I have received your additional heads. You can accept that I have gone through them.
Indebted, Your Ladyship. Thank you very much, Ladyship. Your Ladyship, as previously indicated, the position of the applicant is still as covered in the notice of motion, whereby the applicant is praying the Honorable Court to declare that the conduct of the respondent, by virtue of his failure to align his consultation process in as far as government notice Gazette number 46048 for public consultation in terms of section 90, bracket 4, bracket A of the National Health Act be ultra vires and invalid. Or alternatively, Your Ladyship, declaring that the consultation process followed by the respondent in terms of section 90, bracket 4, bracket C of the National Health Act is ultra vires and invalid. Further, Your Ladyship, compelling the respondent forthwith to withdraw government notice number 46048 for public consultation, which he instituted in terms of section 94C of the National Health Act. In the alternative, compelling the respondent to forthwith withdraw government notice under Gazette number 46048 for public consultation, which he instituted in terms of section 90, subsection 4, subsection C of the National Health Act 61 of 2003, and to revise the provision for consultation in alignment with section 94A of the National Health Act. We had indicated, Your Ladyship, in our notice of motion that as far as cost is concerned, compelling the respondent to pay costs of 2 counsel. But in this instance, Your Ladyship, will pray leave of the Honorable Court to amend that to 1 counsel and further and alternative relief. Your Ladyship, the thrust of this matter basically revolves around the proper interpretation and therefore application of section 90, bracket 4, bracket A of the National Health Act and also Section 90, bracket 4, bracket C of the same National Health Act. Your Ladyship, I'm not going to burden the Honorable Court by going through the aspects related to the applicant's heads of arguments in isolation of the response to the issues raised by the respondent. So what I'll do is that in addressing the court, I will talk to the issues as pertains the relief sought and therefore the issues that the respondent has spoken to. May I have his responding affidavit?
Mm-hmm. Mr. Sibanda, in addressing me on the issues, you're also going to have to address me on urgency. I know I've seen your papers where you said the court dealt with urgency on the last occasion. But on the last occasion, I inquired from the applicant whether or not how and when they came to know of the regulations was important because it dealt with the issue of urgency. I don't know whether you have got any further submissions to make, because if I recall correctly, your argument was, or your submission was, there was no obligation on the applicant to find out when these regulations were made. How it came to its attention is not relevant. And if I am misstating the submission you made, I apologize and I invite you to correct that submission. Because one of the relief you're seeking is that the non-compliance with the rules or the norms of and forms of service be condoned, and that the matter be dealt with as one of extreme urgency. Mr. Sibanda, I think you seem you seem a bit frozen, sorry. There's a bit of a problem with your connection. You seem to be frozen.
Am I back okay now, Your Ladyship?
I can hear you slightly, Mr. Sibanda, but the image is still very distorted and very frozen.
May I try and arrange a different connection and see if that will work, Your Ladyship?
I'm hesitant to do so in case it doesn't work.
My lady, yeah, I was dealing with the Western Cape High Court matter this morning, and I don't think the device is the issue. I think it's just the Wi-Fi. So could I perhaps suggest that Mr. Sibanda continues as long as Your Ladyship can hear him, because I don't think changing device is going to solve the problem.
Mr. Sibanda, if you don't mind, what I can suggest as an alternative is that I put my camera off, because it's been my experience that if there's less people with cameras on and microphones on, the better the connection. So I'll put my camera off if you don't mind. It doesn't mean to say that I'm not listening to you or hearing your argument. I just want to facilitate a better connection.
Thank you, Your Ladyship.
If I don't hear you, I will bring it to your attention. Yes. You may proceed, Mr. Sibanda.
Thank you, Your Ladyship. Your Ladyship, this would have to go down as a classic case of miscommunication between the court and therefore counsel, because when the issue of agency was raised the last time and the responses were made and the arguments further made as regards the importance of the matter and therefore the agency of the matter, my understanding was that the Honorable Court had dispensed with the question of agency, and hence the reason why, even in the proposed draft order, which we agreed upon in court, there was the word urgent, which when my learned colleagues went and finalized, they dropped the word urgent. So for that particular reason, I did not
Harrison, I
seek
can't hear you.
further instruction.
Okay. Mr.
beg your
Sibanda, I lost
Yes,
you. The
ladyship.
connection dropped. The connection dropped after you said that you were under the impression that the court dispensed with the issue of urgency and even the terms of the draft order. And that at that stage, the connection dropped.
Yes, even in the terms of the draft order, as the court was reading out what should be contained, the word urgent was part of what the court spoke to. But when my learned colleagues went and finalized the draft order, it would seem somehow the word urgent somehow dropped. And for that reason, I did not take further instructions from client as pertains the issue of how they got to know, besides to say, Your Ladyship, this then addresses itself to the classic issue as pertains to the necessity for this matter to be treated urgently from the perspective that the people of South Africa are in a very difficult position. And the difficulty being raised by the fact that the scenario as it stands is such that if this matter is not dispensed with, and this I emphasize, as I did emphasize the last time, the Odekral principle will kick into play. And once the Odekral principle kicks into play, it means a law which is also res and invalid will have legally recognizable consequences against the people. And besides, Your Ladyship, the issue of urgency should not of its own be the basis upon which the matter is finally decided in as far as the people of South Africa are concerned, in the sense that the most important thing is that the applicant has come before the court, and the most critical issue that the court, I humbly submit its mind to, is whether sending ourselves with the strict application of perfect procedural steps, or should we be concerning ourselves with the necessity and importance of applying justice for the benefit of the people? Because the scenario as it stands is that if we are to confine ourselves to the strict procedural steps, we are prejudicing the people of South Africa. And Your Ladyship, I would submit further that the case of Nelson Mandela Metropolitan Municipality is authority for the Your Ladyship, for the fact that the rules that the court has set for itself should not be rules that of themselves bind the court to the extent that it cannot dispense with justice.
I'm aware, Mr. Sibanda, sorry to break your word. I am aware that form over substance can never triumph. But when we're dealing with issues of urgency, procedural issues sometimes translate into substantive prejudice or merits. Similarly, in your matter, you are saying there wasn't sufficient time. So time, whether it be urgent for procedural, sometimes and very often translates into substantive issues. That's why it was addressed. And you are correct. The court did admit on the last occasion that this matter by its nature is urgent. But the court also questioned the level of urgency or the degree of urgency, because I specifically recall in my interaction with you, you conveyed that when and how the applicant came to know about these regulations are not relevant. And I put it to you, it was relevant for the court to establish the degree of urgency with which the matter was brought. So on its own, the matter is urgent, but it goes to the degree of urgency. But I am aware that form can never trump substance.
Thank you, Your Lady. Your Ladyship is very, very correct that at the last sitting, you did interrogate and I did respond with the humble opinion that how the applicant got to know is not of much relevance under the circumstances. And I did indicate that I'm not going to create a story on behalf of the applicants. But where the confusion came from is that interaction, Your Ladyship, preceded the aspect where the court then spoke to the matter and said it's urgent. So from that perspective, the impression created was that the interaction prior had now been cured, when Your Ladyship even said words to the effect that the argument was compelling. So now, from that perspective, the impression created, which therefore led to there being no further interrogation of the issues, was that the court had accepted the matter as urgent, and the issue was not clear that the court still wanted the degree of urgency to be further interrogated. And I humbly submit, Your Ladyship, that for as long as there is that confusion which prevailed as between the counsel for the applicant and the court, that it be applied to the benefit and to the advantage of the applicant simply and purely by virtue of the fact that this is a public interest case, simply and purely by virtue of the fact that the lives of 60 million plus South Africans stand to be determined purely on a procedural aspect, purely on the fact that between the counsel and the court, there was some element of miscommunication. There was some element whereby the applicant's counsel reached a conclusion. And this is the reason why, even in the affidavit and in the additional heads, the approach of the applicant is that agency has been dispensed with. And that was honestly a humble opinion of myself, Your Ladyship.
Mr. Sibanda, I will acknowledge that there might have been a misunderstanding on the applicant's part. However, no ruling was made by this court on the aspect of urgency. I could not make any ruling on urgency at that stage because the respondent was not given an opportunity to properly engage the matter. But I accept that there might have been confusion on the applicant's part, notwithstanding the fact that no ruling was made by the court on urgency.
Absolutely, Your Ladyship. And Your Ladyship, if I may also humbly submit that by arresting the degree of agency, we run the risk of actually watering down the actual agency of the matter. Actual agency of it being the fact that this is public interest. This is the lives of 60 million people that we are talking about. I am the honorable court that in looking at this further, looking at the element of agency, I request the honorable court to consider the substantial prejudice and the lack of redress that will be available to the vulnerable South Africans should this matter be dispensed with simply and purely on agency and the merits never addressed and articulated. And this prejudice, Your Ladyship, is informed by the fact that the respondent has the ability to cure the defect of his procedure in as far as the manner in which he has gone through with the consultation process. But, Your Ladyship, let's think of the individual South African or the individual South Africans who will be affected by these regulations in the event that they do come to and they are subjected to the provisions of the regulations, where when you look at Regulation 15 particularly, imagine the person who will have been taken against his will or her will into isolation, into forced quarantine, and once they are there, according to the regulations, they may not refuse to be examined and be subjected to whatever examination and supply of some bodily samples which the state deems fit. Not determine how long this isolation quarantine. Further to that, they cannot refuse whatever medication they are given, which means even for those who, for whatever reason, do not need or do not want to be vaccinated, they will have to be vaccinated. And there is no redress to that, Your Ladyship. Once this has been jabbed into the body of an individual, they cannot come out and sue the minister, sue the government, and then extract. They can maybe sue, but they cannot extract what has been injected into them. And so there is no possible recourse for South Africans who have been subjected to that. And with all due respect to the system, Your Ladyship, this is going to affect the weakest of the weak, the poorest of the poor, those who cannot stand up and speak for themselves, those who are privileged by basis of power, by basis of connection, by basis of political affiliation and political office being occupied, will not be subjected to what we are crying about. So that is where the urgency lies, Your Ladyship. Let's protect each individual South African, in as much as this can run its course and the review route is available, accepted, but how long is it going to take? How many people's lives will have been affected by the time that the matter is finalized under the normal review processes? It's those South Africans that we are talking to, Your Ladyship. Hence the reason why the position of the applicant has been, was, and is, Your Ladyship, that the most critical question that the court should be asking itself is not so much how the applicant got to know, but since the applicant got to know, how many lives can be saved by hearing this matter? How many lives can potentially be protected by hearing the merits of the matter and therefore determining whether indeed our interpretation of the law is correct, or is it the government that is correct? So, Your Ladyship, in as much as there are review processes to challenge the regulations as they are, there is no process whatsoever that will bring back to life the individual who may be jabbed, whether they've got other issues.
Sorry, Mr. Sibanda, you've just said now that the review route is an acceptable route, but you do not, Mr. Sibanda, can you hear me? Mr. Sibanda, can you hear me?
I can hear you, Ladyship.
Yes, thank you. Mr. Sibanda, I can hear you, yes. You've indicated that the review route is an acceptable route, but how many cases will be affected before the review route is finalized? But isn't the remedy of interdicting the implementations while the actual regulations are challenged? And that the actual regulations, once it's passed in its final format, are not implemented pending a challenge to those regulations.
If we were dealing with regulations which are intra vires, I would agree with the Honorable Court. But in this particular instance, we are dealing with regulations which are stillborn. So there is no way that, Your Ladyship, we can be looking at a scenario where we are saying, we can see that this child is dead. and yet say, let's wait and see in 2 years' time if the child will be able to walk, because there is nothing that is going to happen. So, Your Ladyship, if indeed the position that has just been articulated by the Honorable Court was informed by the fact that the process that has been legislated, the process that has made it an obligation upon the respondent to follow. If it had been followed, I would agree with Your Ladyship and say, yes, Your Ladyship, we can take that particular route, wait for the regulations, and then we interdict the operation. And in so doing, we would also have to be cognizant of the fact that we would be running the risk of now being caught in a situation where we are perceived to be interfering with the process before it is finalized. Unless if Your Ladyship is saying we wait for the regulations to be finalized and we challenge them before promulgation, that will be a more difficult task for the applicant than it is to have this matter dealt with from a perspective where the people of South Africa are basically afforded basic minimum democratic rights in the process of making laws that speak to their reality. We are not here talking about democracy informed by putting an X against a ballot box and then hoping that next time these people are going to do the right thing. This is informed by a situation that says, Your Ladyship, as soon as these regulations come to, people's lives are at risk. These regulations are not aimed at protecting Your Ladyship. That is the agency that we are confronted with here, that the people of South Africa cannot be denied a right to say, yes, we submit to the possibility of our lives being turned upside down overnight, being locked up in quarantine and being denied the right of our relatives to come and see us because the government has decided that we're sick, because I've been suspected of being sick, so I should be subjected to all these procedures, because I've been in contact with someone who is suspected of being sick, or in contact with someone who has been tested as being sick, therefore my life has to be subjected to someone else's interpretation of what is good for me. The people of South Africa did not...
Mr. Sibanda, I think you're going off the point now. That is not what your case is about. Your case is about the time period that needs to be given. And you are now...
I apologize, Your Ladyship. Please do, please. I apologize.
Yes, and Mr. Sibanda, I accept that you are very robust in your argument, but this is still a court of law. It's not a lectern to preach at. So make legal submissions, please.
Your Ladyship, it's unfortunate that the nature of the question that the court has presented requires that the law be substantiated by a further argument, in the sense that...
yes, legal argument, Mr. Sibanda, not emotional argument. Not emotional argument.
Indeed, Your Ladyship. The legal argument, Your Ladyship, is premised upon the fact that, as indicated, amongst the crucial tests is whether the applicant or the applicant is representing will have substantial redress in the unlikely or in the event that these regulations go through. And as I've indicated, it's unfortunate that Your Ladyship deems it as emotional, but the issue is that should the regulations go through, the agency that we are talking about, and the agency, if you look, for instance, Your Ladyship, at the case, we've quoted it in paragraph 29 of our heads. In
Is that the additional heads or the original heads, Mr. Sibanda?
The
Is that
original head,
the original heads?
Heads, Your Lady. Yes, Your Ladyship, at paragraph 29.
Yes, I've got it.
The ISRA case is authority for the aspect related to this substantial redress that I am talking about. And in paragraph 30, further, it basically consolidates the point that if substantial redress cannot be afforded at a subsequent hearing, the matter qualifies to be heard and enrolled as an urgent application. So
I hear you. However, let me pose this question to you. The respondents say that this application is premature. Furthermore, that the Constitutional Court has said that the court needs to stay in its lane and that it can only interfere in legislative processes in exceptional cases, and that this is not an exceptional case for this court to interfere with the legislative process at this stage of the draft regulations.
Your Ladyship, the aspect as pertains to the prematurity of the case as perceived by the respondent is premised upon the fact that the respondent is addressing himself to another case other than that has been brought by the applicant. In this, there's nothing premature by saying the law says afford the people at least 3 months. Therefore, if you give them any less, you have violated the law. If the applicant was saying, I am challenging the regulations, then I would have to agree that definitely this is a clear case of a premature application. The aspect that they are talking to as related to prematurity is not relevant to this case, Your Ladyship, because the limited approach of this case has deliberately been structured so that we don't confuse ourselves with peripheral issues. The question that is presented before the Honorable Court is, does Section 90, bracket 4, bracket A of the National Health Act compel the respondent to afford the people of South Africa at least 3 months or not? Secondly, the question is there any law that the respondent is able to rely upon that justifies departure where public consultation is concerned from the at least 3 months period to the 30 days that the respondent has afforded? Thirdly, the question...
Sorry, Mr. Sibanda. The respondent in their heads of argument say there may not be a law per se, but the principles of statutory interpretation, or rather the principles of interpretation, would not result in the interpretation which the applicant is giving to Section 90, subsection 4, subsection A, and Section 90, subsection 4, subsection C, that the singular interpretation or which the applicant contends for is not substantiated by applying the principles of interpretation to the Act and to the sections.
Yeah, Ladyship, with all due respect to the court, Your Ladyship posed questions which I had not fully finished answering.
My apologies, Mr. Sibanda.
Yeah, thank you, Your Ladyship.
I must say it's a bit difficult when one interacts virtually because there is a bit of a lag and it's difficult because you can't see counsel in person. So I apologize for that. But if you could make a note of that question and then address me when you're done with your original answer.
Okay. So, Your Ladyship, we were still talking to the issues of prematurity of the application, and basically saying the manner in which the state is approaching that is not in line with the question. So the third question that I was presenting as the question that the Honorable Court should be basically dealing with, and which is the question that the respondent should have been talking to in the papers. Firstly, it was the at least 30 days aspect. Secondly, it was whether there is a law that speaks to, the at least 3 months, and whether there is a law that speaks to the 30 days. And then the third question is whether, Your Ladyship, Section 90, bracket 4, bracket C, of the National Health Act gives the respondent latitude to play around with time or not. Those are the three fundamental questions that have been brought by the applicant, and those are the three fundamental questions that the respondent should have been answering to, and not asking itself questions and answering the wrong answers, because those are not the questions posed by the applicant. So, Your Ladyship, Your Ladyship also raised the issue as pertains to the role of the court and intervention in as far as the legislative process is concerned. Your Ladyship, in as far as the principles of interpretation, we will be talking to that. It's already part of our argument, and to show the fallacy behind the limited interpretation of that aspect in as far as the respondent's approach to interpretation is concerned. As regards the role of the court, Your Ladyship, in the case of Doctors for Life, which case is so it's captured in the original head. Sorry, Your Ladyship. Your Ladyship, at paragraph 69 of Doctors for Life, one of the things that the court addresses itself to, this is the Constitutional Court, where immediate intervention is called for in order to prevent the violation of the Constitution and the rule of law, courts will intervene and grant immediate relief. That is a power that is available to the court, as indeed the court proceeds to say. Intervention will occur in exceptional circumstances. Absolutely. It has to be in those exceptional circumstances, as where, this is where the court qualifies it, such as where an aggrieved person cannot be afforded substantial relief once the process is completed, because the underlying conduct would have achieved its object. So the authority of the court, Your Ladyship, to intervene is informed by the fact that there is a violation of the rule of law. The rule of law in this particular instance covered by Section 94A of the National Health Act, which says the people of South Africa must be afforded at least 90 days. So now, if the violation which we are currently sitting with, of giving the people 30 days and then affording the people 2 extensions, which of themselves are also stillborn in the sense that they are also ultra vires, then the aggrieved people, namely the people of South Africa, cannot be afforded substantial redress once this process has gone through. Because only then they will be challenging the regulations. They won't be challenging the process. They won't be going back to the process. So now what we're saying is, before allowing this to go through, let's get it right from the beginning. The honorable respondent had the ability to get it right from the beginning, and he never did. In paragraph 70 of Doctors for Life, the honorable court continues to the primary duty of the courts in the country, Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. And if in the process of performing their constitutional duty, courts intrude into the domain of other branches of government, that is an intrusion mandated by the Constitution. What the courts should strive to achieve is the appropriate balance between their role as the ultimate guardians of the Constitution and the rule of law, including any obligation that Parliament is required to fulfill in respect of the passage of laws, on the one hand, and the respect which they are required to accord to other branches of government as required by the principle of the separation of powers. I humbly submit, Your Ladyship, that this is a classic case justifying the right of the honorable court to intervene in the passage of law, because the primary stage in the passage of these regulations is covered by section 90(4)(a) of the National Health Act, and the minister has not fulfilled that requirement. Hence the reason why the court is authorized to step in. As the Constitutional Court has made it clear, the court does have the authority, it does have the right to step in and protect the people. And it's good that in this particular instance, the learned judges made it clear that this intervention by the court speaks to the passage of laws. So, Your Ladyship, that is where we are right now. What was that question the judge asked?
The interpretation.
I beg your interpretation.
Interpretation. The respondents say that your interpretation of section 90.4.a and section 90.4.c are not consistent with the principles, the accepted principles of interpretation.
Your Ladyship, it is important to premise my response with the submission that in as much as that is what the respondent is saying to the honorable court, the respondent is actually not coming with what it considers as the right interpretation informed by the principles. Let's look at the principles, Your Ladyship. Your Ladyship, the point of emphasis on the part of the respondent is the Ndumeni case and how Justice Wallace basically came up with the issues as pertains to the aspect of text, the aspect of context, the aspect of purpose, and how in the interpretation we are no longer bound by the old approach to interpretation. Now he is introducing this new approach. Your Ladyship, one of the important things that Justice Wallace addresses, I'll speak to these points in 10, where Justice Wallace says, interpretation is the process of attributing meaning to words in a document, be it legislation, some other instrument, contract. And what do we have to have regard to? The context provided by reading the particular provision or provisions in light of the document as a whole. That is one of the core fundamentals of where we have to start from, Your Ladyship. We have to look at the document as a whole. Let's look at the National Health Act. when we look at the National Health Act, Your Ladyship, we have to look at it from a perspective that says, given what Justice Wallace has already spoken to, the four walls of the statute will tell us exactly what we are looking for. We don't have to bother ourselves, as indeed it used to be in the past, with trying to ascertain the intention of the legislature. Justice Wallace gives the people very succinctly. And I am with you that the Honorable Judge. So when you look at the part, which I will refer to as the head note of the Act, if you look at the very introduction prior to the preamble, why is this Act in place? It says to provide a framework for a structured, uniform health system within the Republic, taking into account obligations imposed by the Constitution and other laws on the national, provincial, and local governments with regard to health services. So here, Your Ladyship, if we are looking at the context of the passage of this particular legislation, and therefore look at the context of Section 94A, we have to go back. This Act came into place in the first place. It had come into place to create a framework, which framework takes into account obligations imposed by the statute. Obligation according to place.
Mr. Sibanda, can you're breaking up? Can you just repeat that last submission?
I'm not sure at what point the court lost me.
The head note of the Act and when it came into operation. You went through the head note of the Act, and then you were saying you need to look at when it came into operation. And at that stage, you started breaking up, and I couldn't follow what you were saying.
Sorry, I think we must have missed each other. I'm not so much looking at when it came into operation, Your Ladyship. I am looking at the basis and the reasoning behind why it came into operation, so that we can then be able to address the text, we address the context, and we address the purpose. Because
so sorry, that's why I said you were breaking up. I couldn't hear exactly what you were saying, and that's why I asked you to repeat it.
I appreciate that point, Your Ladyship. I have no objection to that at all.
Yes, you must proceed.
So what I'm saying, Your Ladyship, is that Section 94A, let's look at it in line with, according to, and informed by the head note. What is this Act really aiming at achieving? Providing a framework. A framework for what? For uniform structure, uniform system. And what does it take in? The obligations imposed by the Constitution, number one. Interpreting Section 94A, we cannot interpret it outside the head note, and we cannot interpret it outside Section 59 of the Constitution, which affords the people of South Africa the right to a participatory democracy. And it says other laws. The other laws that we are looking at now is the Act itself. The Act itself provides for at least 3 months of public participation. So when we look at our context from that perspective, when we look at the whole document and also looking at the preamble, let's look at the second bullet point on the preamble. The idea further behind this Act to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. No one needs to be lectured on the divisions of the past, which divisions of the past were even evident within the medical healthcare system, whereby those who were deemed to be subhuman were subjected to a different reality than those who considered themselves human. And at the same time, those who were deemed to be subhuman or non-human altogether were denied any sort of democratic values. So this act comes in and says, we need to heal that. How do we heal it? We introduce within the National Health Act aspects which speaks to democracy and therefore allow people to have a say in issues that speak to their health. During apartheid, those who were marginalized did not have a say. That is why it was easy to experiment upon them. And in this particular instance, the Act says we are not going to have it again. And this is why, in this particular instance, the applicant is also coming before the Honorable Court and saying it's not going to happen again, that the people of South Africa will be denied a voice in as far as democratic values are concerned, in as far as social justice is concerned, in as far as their fundamental human rights are concerned. Any other interpretation that runs away from giving the people of South Africa their full democratic rights, their ability to enjoy their social justice, their ability to have the mental human rights.
Mr. Sibanda, I'm losing you.
Violate.
Mr. Sibanda, I've lost you. I last heard any interpretation that runs away from the people's right to enjoy their fundamental rights. That's the last part I heard.
Your Leadership, may I request that I request for a dongle that maybe is the gadget I'm using that is causing us to have the breaks in connectivity, because I realize that between my losing each other.
Mr. Sibanda, are you requesting the court to provide you with a dongle, or are you requesting that you be allowed to switch devices? I can't hear you.
I think I can. I'm requesting for the right, Your Ladyship, to switch dongles, not for the court to supply a dongle, but for me to get another dongle within the courtroom, and then maybe we'll be able to continue with little or no disruption. Because I appreciate the frustration on the court as well.
Yes, I've been trying not to interrupt your argument, Mr. Sibanda, but it's not fair to, if I can't hear what you're saying, to not bring that to your attention. Is there a dongle available in court, or do you need to get one? What is the position?
I would love to check first if a dongle is available. I think a dongle is available in court, and if I can get access to a dongle, I do believe within the next 5 minutes, Your Ladyship, we should be able to have that aspect resolved.
Okay.
Because I'm not upset with Your Ladyship interjecting when the communication has broken down. I really respect that and appreciate that.
Okay. Mr. Sibanda, it's now 2:30. I'm going to give you 2 minutes. I can't give you much more than that, because I must still hear Mr. Willis and I must still hear Mr. Budlander, and then I must give you an opportunity to reply.
Indeed, Your Ladyship.
We've already been in this hearing 2 hours. I'm not going to limit the parties, but I'm conscious that we are dealing with court staff as well, and that everybody needs to be given an equal opportunity to have their say. So I'm going to switch off my camera and my mic for 2 minutes only to allow you an opportunity to try and switch to a device.
Thank you, Your Ladyship.
Well, there you have it. Just a short 2 minute break, real quick, just to sort out the internet connectivity there, because it is absolutely crucial that the judge hears every word that is being submitted. And that is what is meant with each party must be fully heard. Okay, that's the fairness principle that has to be applied. So just bear with the court there a few minutes. Those of you who, if perhaps at that point that Isabella was raising there about the interpretation of the law, he's referring there to a piece of case law, which hopefully afterwards we can put up for you. I've shared that link already with a few people. But what he is saying there is that when we're looking at law, or we're looking at a piece of text, for interpretation, you have to consider the text, the context, and the purpose thereof. And as you've just heard Sabelo pointing out there, that back in the past, that these elements were actually quite important, that they were brought in afterwards on the back of the history of South Africa. Because way back then, people were in fact excluded from the legislative process. The legislative process is the issue at hand here. Your right to participate. And that right to participate also goes down to the right of your bodily and psychological integrity, which is covered in the Constitution, that you have to be able to participate in decision making that will affect you in any way. You know, if none of these regulations which are contemplated were going to affect you, you need not be consulted. But given that we are being consulted, it means that this will affect us. And if you're going to be consulted, you have to be consulted consistent with the law. This is why that was written into the law. You should give the public at least 3 months, because it's a public participatory protection that is built in. So to make sure that people aren't overridden with laws, or laws are just being written and people just have to deal with it later on. No. This is the idea of participatory democracy, so that there is public agreement about any piece of law that is being made. This is what it is. You can tell that the state is trying to make the case about us being here about the regulations. No, we are not here about the regulations themselves, because the regulations are not law yet. They're not law yet. They are being contemplated. Our concern is the consultation process. That's what it is. That's what y'all got to remember. Nothing else. The court, I mean, the government tries to give another impression. Okay, the
leadership, I think we're good. Just a minute to settle down. Yeah, we've changed that. Yes, thank you.
Thank you, Mr. Sibanda.
Leadership. My sincere apologies about that, Your Ladyship.
As long as the connection is better, Mr. Sibanda, then let's push forward. Mr. Sibanda.
Your Ladyship, there's a bit of a glitch in switching over. I sincerely apologize for that.
No problem, Mr. Sibanda, as long as we can go forward and that there's a better communication. I must say your image is much clearer than it was.
I think it's the same. Yeah, I fully agree, Your Ladyship. Even on my side, I think it's better. If Your Ladyship could kindly indulge me as to assist with the last aspect that the court was able to glean from what I was saying, so that I can continue from there.
I think you were dealing with the second bullet point of the preamble of the Act, and you were saying any interpretation that runs away from the people's right to enjoy their fundamental rights cannot be sustained.
Absolutely.
And I'm plagiarizing a bit. It's not your exact words.
I appreciate that, Your Ladyship. So, Your Ladyship, this is all still within the principles of interpretation, where we are interpreting, looking at the entire document. So the bullet point number 2 addresses that aspect. And then bullet point number 3, the preamble says that amongst other imperatives is the need to improve the quality of life of all citizens. So, Your Ladyship, when we look at Section 94A, again, within the context of the third bullet point, the reason why we have to interpret...
And to just close all the windows also. I'm coming just now. I'll be back just now. I'm just going to go to Woolworths quickly.
I'm again going to ask everybody who is not addressing me to please put your mic off. Otherwise, you will be removed from this hearing. We do not need to know that you need to close windows or need to go to Woolworths. Thank you, Mr. Sibanda.
Thank you, Your Ladyship. So, Your Ladyship, when we look at Section 94A, within the context of the third bullet point, that at least 3 months being afforded the people of South Africa speaks to the improvement of their quality of life. Because we've already seen in the Act that the important thing is for people to have a democratic engagement with legislation. Why a democratic engagement with legislation? So that the need to improve the quality of life of all citizens can be addressed. And so now, if we limit the period of public participation without any justification, the question that has to be asked, how does this assist the people of South Africa improve the quality of their lives by engaging in the democratic process that speaks to the passage of law? Because I will emphasize, Your Ladyship, this is talking about the quality of life of all citizens. So when we now interpret subsection 94A, looking at the principles of interpretation, the question that we ask ourselves is affording 30 days to a population of 60 million odd South Africans an opportunity to comment on regulations really be said to be addressing all citizens? We see that in both the affidavit of Ms. Lombard and the affidavit of the respondent, there is mention of the fact that by the 6th of April, 180,000 South Africans, by the 6th of April, 180,000 South Africans had made submissions. Your Ladyship, the question that necessarily arises is, does it honestly make sense for regulations that were passed, signed off by the respondent on the 14th of March, and distributed, supposedly, to a population of 60 million odd South Africans, only 180,000 respond, particularly within the context, Your Ladyship, of a country where the bulk of the population resides in the rural areas, where, Your Ladyship, the bulk of the population within the city cannot afford some of the privileges to Wi-Fi, to data, to gadgets that can speak to how government wanted the submission done. Not only are the people given 30 days, they are told to submit via email. Our people in the deepest of the rural Limpopo, Mpumalanga, Eastern Cape, Northern Cape, going to submit via email. So already that of itself shows that the necessity to respect the at least 3 months provision allows government an opportunity to reach all the citizens, because all leaves no one out as long as they are a citizen of this country. And so now, any other interpretation that denies the right of some of the citizens to participate by virtue of the fact that time has not been allowed for everyone to have an equal say is therefore contrary to the spirit of the Act, and once looked at contextually, it does not speak to the relevant context, and it does not speak to the purpose of the Act. And further, on the preamble, the first bullet point after it says, bearing in mind that the state must, in compliance with Section 7.2 of the Constitution, respect, protect, promote, and fulfill the rights enshrined in the Bill of Rights, which is a cornerstone of democracy in South Africa. And amongst the imperatives there is the provision as relates to equality. Your Ladyship, for as long as the 30 days that the respondent has allowed the nation only allows those who are privileged to participate in democracy, that is a clear violation of the constitutional prerogative of equality. There are some people who this democracy is living out, and the approach by the respondent is necessarily talking to that particular aspect. And further, Your Ladyship, one of the things that is important to realize, in as much as the aspects spoken to above relate mainly to subsection 94A, let me talk to 94C within that same context, in the sense that the head note, the bullet points covered in the preamble, in being looked at vis-a-vis subsection 94C, the question that has to be asked is, does 94C address these concerns? The answer will have to be, yes, it does, but where there are circumstances that necessitate for the respondent not to consult. And it's very clear, because it says this aspect is made reference to vis-a-vis the consultation contemplated in subsection 94A. And so
Mr. Sibanda, in respect of section 94C, that provides for immediate publication without any comment, had the respondent published the regulations in accordance with section 94C and said, well, the urgency with the lacuna of the regulations coming into effect and the declaration that the national state of disaster is coming to an end are such that it's one of those matters where no comment period must be allowed, would we still be here?
No, we wouldn't, Your Ladyship. We would be in a situation where we are seeking for a review of those regulations that would have been passed in terms of Section 94C. We would not be arguing at all.
So if I understand your position correctly, had the minister published the regulations in accordance with provision 94C, you'd not have challenged that particular section, but you would have challenged the product.
Your Ladyship, you are absolutely correct, provided that the respondent would have applied properly the provisions of 94C, because the reason why we are sitting here is because the respondent, in issuing out Government Gazette Notice 46048, references 94C. This is what it reads. The minister intends, in terms of Section 91, J, K, and W, read with Section 94C of the National Health Act 2003, and after consultation with the National Health Act, to make regulations contained in the schedule hereto. And then goes on to say, interested persons are invited to submit within 30 days. That is where he got it wrong. If he had simply stopped at making the regulations, he would have been very much in line with the provisions of subsection 94C. But he quotes 94C and then invites public participation. Whereas the actual reading of the Act, the minister may, if circumstances necessitate the immediate publication of a regulation, publish that regulation without consultation contemplated in paragraph A, which basically means if the minister, given the circumstances that he deems necessary, it gives him the discretion. I respect that. As long as there are circumstances which he deems necessary, he can immediately publish. And it says without consultation. That is the critical point. He may publish without the consultation contemplated in paragraph A, and which is the contemplated consultation in paragraph A. The contemplated publication, or rather consultation, in terms of paragraph A is that the minister must publish all regulations proposed to be made under this Act in the Gazette for comment at least 3 months. So now what the Act is saying, C is saying, I am alive to enable the minister to issue immediate regulations. And in being alive to that aspect, the minister does not have to comply with A, where A says he must publish and put out for comment at least 3 months before the date contemplated by their commencement. So it's very clear. We've got two positions and interpreted in lines with the head note, which is looking at the health of the people, which is looking at democracy. It is saying, for as long as the minister is convinced that there is such a serious issue that has to be attended to, then he does not have to consult. He must protect the health of the nation. But in this particular instance, he cites 4C, which in itself precludes him from consultation. And then he proceeds to consult. And there is no way, Your Ladyship, that this can be interpreted to mean that there is a range of possibilities. Immediate is immediate. At least 3 months is 3 months. There is no way within the context of this particular section that the minister is empowered or enabled to cut the period from anything less than 3 months, and there is nothing that says the minister may, where it is deemed necessary, and he can immediately publish, choose to consult instead. So from that perspective, it is clear, Your Ladyship, that in the interpretation of this particular section, it is absolutely critical that we apply our minds, yes, to the principles as covered by Endumeni, but we also have to be wise to the fact that Endumeni, regardless of having been endorsed by the Constitutional Court in 2014, the Constitutional Court itself is not applying Endumeni. Constitutional Court is still, in some cases, going back and using the old approach, or alternatively, going back and looking at the intention of the legislature. And one of the things that I would like to emphasize as well in the Justice Wallace judgment in Endumeni, the judge is very clear to say that judges must be alert to and guide against the temptation to substitute what they regard as reasonable, sensible, or businesslike for words actually used. And here we've had the argument raised by the respondent that our interpretation will lead to an absurdity. They don't indicate what sort of absurdity this is likely to be. They say that it will lead to an unbusinesslike result. I don't know what is unbusinesslike by giving people their rightful at least 3 months to be consulted. And I do not know anything that is unbusinesslike by saying that the people must, the minister rather, must not be able to exercise his prerogative in terms of Section 94C. What we are caught up with here, Your Ladyship, is that we are in a situation where after the fact, in an attempt to justify the unjustifiable, the respondent is now coming up and applying interpretation to a situation where it does not apply. And yes, the law is clear as well, that where there is a possibility of more than one meaning to a word, then we need to take the objective and not the subjective process. We need to take the sensible meaning preferred to that which leads to something that is insensible. We need to take the business-like result. The question that has to arise, Your Ladyship, looking at Section 94A, particularly the operative parts of that particular section, the minister must publish. I'm not sure what other meaning can be arrived at on that particular aspect for us to be able to say there is more than one meaning, and because there is more than one meaning, we therefore have to interrogate the issues any further than the ordinary standard meaning of the word must, which was covered adequately, paragraph 14 of the Doctors for Life case. And again, if we look at least 3 months, the minister must publish all regulations proposed to be made under this act in the Gazette for comment at least 3 months. I'm not sure what other meaning can be attributed to at least or 3 or months. And in this particular instance, Your Ladyship, yes, I've seen how the respondent has coined the term default 3 months. So for at least the respondent has come up with the word default to maybe suggest that to the phrase, at least there is some other meaning, which is default. The question that we have to ask ourselves is, if indeed the respondent is correct by this word default, is default and at least at conflict with each other? Because if we were to use the word used by the respondent, we would read it and say, for comment within a default period of 3 months, where if we have to understand the word default, and I noticed that the respondent has not indicated what its understanding of default is. So I will present my own understanding of default. Where default, in my understanding, means something that will occur automatically without any intervention. So meaning, therefore, that when they are using the word default, they are agreeing with the Act that this is the automatic position that has been put by the Act. Any other will be an intervention. Or maybe let's look at it from a perspective of IT. I'm not an IT guru, but I've heard within the context of computers, where a gadget is set, you use your gadget, and you can get it to default to its original settings, which basically means you are taking it back from what it was before there was intervention in it. So in this particular instance, what we are basically saying, therefore, is that if we are to take the word default as used by the respondent, we understand it to mean that the respondent is agreeing with us. That 94A says there is an automatic position, which is minimum of 3 months. But it cannot be also be said to mean that 3 months is the period. When it says at least, it means that is the minimum. If the minister had decided to make it 4 months, 5 months, 6 months, we would not be sitting here. But because he decided that he wants to take away the right of the people from there at least 3 months and make it 1 month, that is why we're sitting here. So I don't see where we can even begin to imagine that there is a possible different meaning to the word must, which, as captured in our heads of arguments, talks to an obligation just as much as the case as regards Doctors for Life captured. And let me draw a parallel between the Doctors for Life case and the case that is presently before the court. In that particular instance, the issue that the court had to grapple with, one of the questions that was before the court was the applicant's contention that the respondent had been in violation of Section 72 of the Constitution in as far as affording public participation. And the learned court had to deal with the meaning of the word must. The learned court, in dealing with the interpretation of the word must, interpreted the word must in exactly the same manner that we are interpreting it in these particular proceedings. And not once have we had the respondents present an alternative interpretation to the word must, and therefore creating a range within which the respondent can play around with in as far as giving people time. Let's go to 94C. Again, the minister may. Our basic understanding of may is that it bestows an element of discretion upon the minister to do or not to do something. I'm not aware of any other interpretation that we can put on that. The reason why I'm just focusing on this is because these are the operative aspects of these sections, Your Ladyship. I don't want to interpret and break down each and every word. It's the operative aspects. The minister may, if, and the word if, Your Ladyship, denotes a scenario where it is conditional upon something happening. I'm not aware of any other interpretation within this particular context. So the minister may, should there be, in the event that there are what? Circumstances. If the circumstances necessitate, there has to be something that compels the minister by way of necessity. And the reason why, it is not a mistake, Your Ladyship, for this to be phrased in the manner that says, if circumstances necessitate the immediate publication, because it is understood that necessity has to be interpreted together with immediacy in this particular instance. So it is basically saying the minister has the discretion in the event that there is a situation, there is a circumstance that makes it necessary to interpret, or rather to publish with immediacy, then the minister has that discretion. And immediate, in my humble understanding of the word, Your Ladyship, means something that has to happen, that has to be done there and then. That is why, even when we structure some orders of the court and say that this must happen with immediate effect, if an order of the court is passed and says to a respondent, with immediate effect, you must do ABC, the respondent cannot come back to court and say, my understanding of immediate was that it gives me the latitude to take it up to 30 days. They run the risk of being held in contempt of court because they have not applied immediacy. And then we go to publish that regulation without the consultation. Without, for me, basically says there is no need to apply the consultation procedure in line with that which has been stated in section 94A. So we are caught in a situation whereby I'm not sure how else you can interpret without, how else you can interpret consultation, how else you can interpret contemplated, for them to come before the court and say that this is an interpretation that leads to absurdity. What is absurd about the respondent, or rather the applicant, saying, respondent, you must publish, and you must do so at least 3 months before? I don't see any absurdity, and I don't see what is not business-like by asking the respondent to comply with the act. But I'll tell you what is unbusiness-like, Your Ladyship, and what leads to absurdities.
Mr. Sibanda, I am going to bring to your attention, you're not going to have very much longer, simply because the parties who are recording this is not going to be around much longer. We are already at 5 o'clock, and the other two parties still need to be able to address me. So I'm going to have to ask you to not, I'm trying very hard not to curtail you, but I have to be mindful of the fact that I'm dealing with limited time here.
Your Ladyship, I appreciate that particular aspect, but I think as well, it would be an injustice to the applicant and indeed the people of South Africa if I would have to rush and therefore miss some of the important points, which I will not be able to go back to.
I'm not asking you to rush, Mr. Sibanda. I'm just asking you to be mindful of the time and be mindful that other parties also need to address me. And furthermore, that the support staff who are assisting with the recording of these proceedings are already outside normal working hours, and it's an indulgence, and they're also going to need to be accommodated.
I appreciate that point, Your Ladyship. So basically, Your Ladyship, what I am saying is that within the context of the principles of interpretation, the respondents cannot be heard, as indeed they have not been heard, to suggest the absurdity that they are talking about. Nowhere in their papers have they indicated what absurdity the interpretation of the applicant leads to, and how their interpretation basically leads to what exactly the statute says. Your Ladyship, in appreciation of the aspect as related to time, I'll just round off this aspect, especially on the Ndumeni case and the literal interpretation of words. I'll just mention the cases which you are going to rely upon to substantiate this point. There is a case of Trinity Asset Management, Pty Limited versus Grindstone Investments, 132 Pty Limited, and the citation is 2018 1SA 94 CC, where we see a classic issue as regards the Constitutional Court quoting Ndumeni case. It quotes Ndumeni in paragraph 52. In paragraph 53, it goes and quotes Sasson Confirming and Acceptance Company, Pty Limited versus Barclays Bank, 1974, 1SA 641A.
Just give me that reference again. Barclays Bank.
1974, 1 SA 641A.
And this is in which paragraph of Trinity?
It's in paragraph 52 and 53 of Trinity, where in 52, the court speaks of Ndumeni as authority, but in the very next paragraph goes and proposes a completely contradictory position, as if they didn't even realize that that is what they were doing. And you find the same thing happen in Reason Limited versus Accelerate Holdings Limited, 2018, 6 SA 571 at paragraph 24, where Mayor J cites Ndumeni with authority for established principles of interpretation, but immediately thereafter cites authority for the determination of the intention of the legislature. So Ndumeni has not given us principles of interpretation that we can therefore say we can rely upon and know exactly how to interpret, because even the Constitutional Court itself does not seem clear as to what exactly we are dealing with. And again, Your Ladyship, paragraph 41 of the 641 versus Mitchell, 2016 3 SA 231, Supreme Court matter. At paragraph 41, Batman AJA cites authority for the old approach, and Ndumeni in the same paragraph, without reference to the fact that the old approach has basically been overridden by Ndumeni, or saying Ndumeni has been overturned. So we are still in a situation whereby the interpretation of statute cannot be determined according to the principles of interpretation as laid down in Ndumeni. And then AfriForum versus the University of Free State, 2018 2 SA 185. I will quote directly from the Chief Justice, as he then was, Mukweng, where he totally overlooks Ndumeni. He says, context comes into operation where the ordinary grammatical meaning is not particularly helpful or conclusive. Contextual interpretation requires that regard be had to the setting of the word or provision to be interpreted, with particular reference to all the words, phrases, or expressions around the word or words sought to be interpreted. So, Your Ladyship, we are in a situation whereby the principles of interpretation are not cut and dry. they are not as straightforward as we would love them to be. I will move on to the question that your ladyship presented earlier as regards the lacuna. Your ladyship, in addressing the issue of the lacuna, I will humbly say to the Honorable Court that the issue of addressing lacuna is an afterthought on the part of the respondent. Let's look at why I am saying this. On the 14th of March, 2022, according to the respondent's own affidavit, maybe and also according to their heads of arguments, indicates that the national state of disaster, I'll refer to paragraph 20 particularly.
I don't wish to interrupt, but as I understand it, this is not part of the case that's pleaded. The case that's pleaded is about the point of law. We're now on to whether the minister had good reasons for the decision he made. And I don't understand that to be part of the case pleaded. I'm happy to address it, but I simply record that I don't understand this debate about reasons to be part of the case.
Thank you.
Your ladyship, the reason why I'm addressing that is because it is contained in the answering affidavit of the respondent, and the court spoke to the aspect of the lacuna. And I cannot leave it unaddressed because the court has put it to me to respond to the issue of the lacuna. And the issue of the lacuna is covered by the respondent. And I thought that
lacuna is basically,
with all due respect to
a
my
blanket period
friend,
or a
that
period
the
on
thrust
hold,
of
a
the
period in which
justification for limiting the
nothing
30-day
happens
period
or
was
things are
because
hanging
of the
in the balance.
lacuna that
It's actually
they
pronounced
are
lacuna,
raising
so you can
as
look it up
an issue.
on
And
Google
that's
as well.
why the court also wanted to be addressed on the aspect of the lacuna. Because we're not the ones who raised the issue of the lacuna.
Proceed, Mr. Sibanda.
Thank you, Your Ladyship. On the 14th of March, according to the applicant, or rather the respondents answering affidavit.
Because basically they are concerned that if there are no regulations in place after the disaster
the national
has ended,
disaster would
then
be
there's a gap
terminated
in which there would
in
be
the near
risk.
future.
That's what they are
We
thinking.
contend
But
that
we don't believe
anything
that.
speaks to a lacuna is a self-created lacuna. Just as much as the court will frown upon litigants who self-create agency, this is a case of self-created lacuna. Having been aware on the 14th of March, the national disaster would be terminated. And then it carries on to say, if there was a need to deal with COVID via DMA measures, they would shift to health. So the respondent was already aware of the fact that there is this shift that has to happen. And he has the law at his disposal to that particular effect. He even says in his own 20.3 that this would have pushed up to June. So he is aware. So there is nothing that would have stopped him advising government that there's nothing stopping him advising government that let's delay on taking away the state of disaster and go through the consultation period so that we don't have a lacuna. That could have been cured in that particular manner. And then, Your Ladyship, let's look at his 20.5. During the lacuna period of his answering affidavit, and we need to contrast that with what he is now saying about, we need to contrast that with the aspects which he refers to as contained in his own annexure MJP1, where in his MJP1, it is clear from the president that on page 1 of his MJP1, he says, over the past 2 years, we have taken unprecedented actions to strengthen our health system. So if this process is about the health of the people of South Africa, it means that the health system of South Africa is ready to deal with that. So there is no issue about a lacuna that we have to worry about, because from how the respondent wants to come out, the lacuna has to be prevented or avoided for basis of ensuring that the people of South Africa are protected as far as their health is concerned. But the president says that actions have been taken to strengthen the health system. We hired more people to deal with the pandemic, built more hospitals and laboratory facility, and ensured that COVID patients are well catered for in our hospitals. That's what, according to MJP1, we are now at a watershed. We are now ready to enter a new
Mr.
phase.
Sibanda, you need not read the whole MJP1 for the sake of brevity.
Indebted, Your Ladyship. And then, Your Ladyship, in MJP2, again it raises the same thing, where the president is saying, although in the fourth wave we recorded higher infections than the previous waves, there were relatively fewer cases of severe illness, hospitalization, and death. So we have nothing to worry about. These illnesses, hospitalization, and death are not an issue. And again, in as much as the respondent talks about a wave coming, where he says there would be where he says that there is an expected wave towards the end of April and beginning of May. There is nothing that has been produced to corroborate that. And even if there was, it still does not address the fact that there is nothing in law that allows him to reduce the consultation period from at least 3 months to 30 days. So, Your Ladyship, that in essence covers the bulk of the issues in as far as the contention of the applicant, that regardless of how the law is interpreted, regardless of how Section 94A and Section 94C are viewed, there is no way it can be said that the respondent has acted intra vires by limiting the consultation period to 30 days. 30 days, Your Ladyship, thank you. And it is important, Your Ladyship, to also look at the fact, that in actual fact, as contained in the replying affidavit of the respondent, this 30-day period that has been covered, even when you look at his MJP5 and MJP6, they don't talk to the 30-day period, because MJP5 speaks to Gazette number 46045, which was replaced by 46048. So that extension that the MJP5 talks to does not really exist. The people of South Africa were duped. And even the email address that is used is totally different from the other email addresses that were provided. Not many people are even aware that these regulations that were being put out for comment, some of them were speaking to regulations which are not addressed to Tsakani Furumela, but there were some which were supposed to be sent to Nkuna, some were supposed to be sent to Medoc, And all these have been slipped under without being spoken to. Within this same 30-day period, they were basically pushed. If you look, Your Ladyship, particularly at paragraph 33 of the replying affidavit, which speaks to at para 17 to 18 of the answering affidavit. That's where it breaks it down. That's where it breaks it down. If you look at what's supposed to be 33.1, is there at 30.1, that on the Government Gazette, number 46045, the name of the official receiving comments is Tsakani Furumela, and the comment period 30 days. The section quoted by the Minister, section 94C, of which he has no authority to do that. And then what is...
Mr. Sibanda, but those regulations are not before me. Those, whether they be correct or not, they're not before me at this stage. And the validity of them are not before me at this stage.
Absolutely, Your Ladyship. The most important reason why I am raising that is because when now MJP 5 is issued, it actually gives life to what does not exist. So now, even when we look at paragraph 35, which is page 11 of the replying affidavit, 35, which is supposed to be, what's supposed to be 35.1 is written there 32.1. Again, we see the same scenario where the regulations that are supposed to be are regulations sent to Tsakanani Furumela. And then now 46, because if Your Ladyship will remember, the notice of motion is about Gazette number 46048. Again, under 46048, under subparagraph 0.2, 32 is written as 32.2. The Gazette number 46048, notice number 1883. The name of the official receiving is Funeka Bongweni. There is no South African that I'm aware of who was responding to this Gazette number and this this notice number, and this notice number is speaking to public health measures in ports of entry, and it's also contained in 46048. So it's asking the people of South Africa to comment to a totally different person, and this one is under the International Health Regulations Act. It's not even under this particular section.
I get that, Mr. Sibanda, but that's going now beyond the scope of the relief sought in your original notice of motion. So I'm not going to go there. I'm going to focus only on the relief sought in your notice of motion and address the case to those issues. I understand about the extension, but as said on the previous occasion, that Gazette, the validity of the extension is not part of the case. The applicant is not challenging the extension of that purported regulations or purported extension for comments. That is not the case made out by the applicant.
I suspect Your Ladyship and myself probably missed each other within our communication. The contention on the part of the applicant on paragraph 35 is not about the extension. It's about the Gazette which the applicant is praying the Honorable Court to declare as ultra vires and invalid. Gazette number 46048. That is what the applicant is before the court on. And what the applicant is saying, as regards regulations relating to surveillance and the control of notifiable diseases, which is point 1, the applicant is the respondent is ultra vires because he used section 94C. And on the same Gazette, which aspect has not been communicated to the people of South Africa, on the same Gazette number 46048, there is regulations relating to public health measures, and these are going to Funeka Bongweni. And we're saying those as well are ultra vires because he gives a comment period of 30 days even when you look at the International Health Regulations Act, Section 3.2 speaks to the powers of the president to enforce regulations. It has nothing to do with him. And there is nothing that I have seen within the context of that act that empowers him to act in place of the president. And then point 3, regulations relating to the management of human remains, again, still under Gazette number 46048. This time the comments are going to Daniel Nkuna. And Daniel Nkuna, the comment period is 30 days. The relevant act, National Health Act, Section 94A. But Section 94A speaks to at least 30 days, 3 months, not 30 days. So that aspect is also ultra vires. And then now regulations relating to environmental health. Again, under it's typographically written there as 46045. It's supposed to be 48. On page 13, the Gazette number is supposed to read 46048. These ones are addressed to Murdoch Kamatuba. And no South African has been sending any comments to any of these people because they are unknown to the generality of the South African citizenship. And at the same time, comment period 30 days. But here there is no section at all that is quoted as to suggest the basis upon which this part of the Gazette may actually be made into law, that the consultation process may be confined to 30 days. So effectively, Your Ladyship, section Gazette number 46048 is rigged with invalidity from beginning to end. Your Ladyship, I submit that is the case for the applicant, and I pray the Honorable Court to grant the applicant the order that is fixed in as far as the notice of motion is concerned, or any other alternative relief. Sorry, Your Ladyship, I think Mr. Pillay wants to say something to me. And thank you, Your Ladyship. I think whatever else comes will be in reply to what my learned friends will have to put before the court. But in essence, that is the...
But Mr. Sibanda, I've on numerous occasions told you about the time. But if you are going to address new matter in reply, you're not going to be allowed to do so. So if there is any issue which you want to raise now, please do so. I'm not going to allow you to raise new issues in reply. You're only going to be able to raise issues in response to what was said by the amicus and by Mr. Badlander. So if there's anything that you want to say that you've not raised, then please do so now. I see also there is a hand up. I'm not sure if that's directed to you, if somebody wants to make a comment to you. But if it's not a legal representative, we are not taking, it's not a question and answer session. So I don't know why the hand is up.
I'm not sure where it's coming from, Your Ladyship. Your Ladyship, what I meant definitely was that I don't see any new issues besides to say, thank you maybe for stopping me there, that according to what the South African people are being asked to comment to within 30 days. There is supposed to be Annexure A with table 1, 2, and 3. There is no South African except maybe the drafters and the respondent who know exactly what this is. So it necessarily means that the people of South Africa have been asked to comment, and the table becomes the most critical part of these regulations, in the sense that it will now specify what the notifiable medical conditions are. As we speak right now, no one knows what these are, but they're just commenting So,
Mr. Sibanda, your challenge was not to the contents of it, but rather to the time period. So if they were asked to comment on defective draft regulations, that wasn't the case made out by the applicant. The applicant's case was limited only to the time period. You can't now go into the defective comment or drafts on which the people were asked to comment. That wasn't the case initially made out.
That is not what I'm saying either, Your Ladyship.
I might be misunderstanding you then.
I apologize for that. Let me rephrase. What I am saying, Your Ladyship, is that by virtue of the fact that people have been given only 30 days, some may not even be aware that there is a missing part of these regulations that they need to comment to. But if it's done within the at least 3 months period, people will have time to study, people will have time to be explained to, people will have time to get this translated into their languages, because the only privileged people group at the moment are the English speaking. No other language group has access to this in their own language. If people had been given the at least 90 days, there would have been ample time to ensure that it is translated into the relevant languages and is made accessible to every South African. Thank you, Your Ladyship.
Is there anything else, Mr. Sibanda?
I think Mr. Pillay is just whispering something to me. No, Mr. Pillay is just highlighting, Your Ladyship, the aspect that even the flurry of applications to participate in the proceedings is an indication enough of the urgency of the situation for South Africans to be heard, for South Africans to be afforded their right to participate within the democratic process. Thank you, Your Ladyship.
Thank you, Mr. Sibanda. Yes, Mr. Willis, you are going to be addressing me.
Fantastic submission there.
If you address me next, and then Mr. Budlander, in light of the fact that you
now
support
the ACDP
position,
is
albeit perhaps on different grounds.
Contribution.
I'm also then just going to ask Mr. Sibanda to switch off his camera and his microphone so that the connection can be a bit stable. Yes, Mr. Willis.
Thank you, my lady. My lady, thank you for your ladyship's patience, and I intend to be brief. My lady, just at the outset, our heads of government are obviously no longer of any importance. Your ladyship get a copy, but we also did deliver a service affidavit, so we trust that all of those issues are dealt with. My lady, there are 4 primary issues that arise. The first that we want to address on is the cause of action. The second would be the correct understanding of Section 94C. We say it is unequivocal. If it's not unequivocal, then your ladyship looks to the interpretation to interpret. The third issue, my lady, is the question whether the application is premature. And then the fourth issue is the minister's defense of justifying his decision, which is probably more a part, ultimately, of the cause of action, but I'll address it as a fourth point. Lady, the cause of action before you lady respect his budget. The application effectively fulfills his budget, and it impugns an administrative decision by the minister to publish in terms of what he understood his powers under Section 90 in the manner that he did it. If your ladyship, in fact, before I get to the next submission, if I ask your ladyship to make a note of the following judgment, I don't want to have to read from it. I want to refer your ladyship to the paragraph. It's the matter of KwaZulu-Natal Joint Liaison Committee versus the MEC Department of Education. The citation is 2013 brackets 4 SA 266, a decision of the Constitutional Court. Lady, I'd like you to make a note of the following paragraphs 28, 68, and 79. Your Ladyship will find therein support for the following submissions. By way of introduction, that matter concerned an amicus in a similar position to ours. Secondly, my lady, what the judgment deals with is the labeling of a cause of action, and that one must be cautious and, in fact, not go to the labeling of a matter. One must look at the underlying facts and what is clear. In that matter, further down below, paragraph 59, in fact, a point made by Justice Frinneman, that there the applicant, or sorry, the respondents, could have put up a record of decision. In this case, the minister has given you his reasons because he knew and understood this to be an application under PAJA. That's why he sought to justify his decision. No criticism can befall the applicants for not using Rule 53.4 or not calling it an administrative action decision under PAJA being impugned. Lady, if you look at the notice of motion, I'm not going to read it. Your Ladyship makes a note. Prayers 2, 3, and 4 also make it clear from the outset what these applicants seek of this court. They do not seek an interdict, my lady. Therefore, your Ladyship's initial question as posed to Mr. Sibanda to argue an appropriate question, but I'd submit the answer to that is, my lady, alternative remedy is not the issue, not in issue here. Your Ladyship would understand that submission. And my lady, what we submit is that what your Ladyship must do is simply apply the law. In other words,
sorry, Mr. Willis, is the invite for comments an administrative action?
Yes, it is, my lady. Absolutely, it is. That it definitely is, my lady. And if one compares that to a tender, for example, a publication of a tender is an administrative decision. The decision to procure, is executive. That would fall under another attack. In this case, the decision to publish is power to decide to publish it with or without comment, or to give an opportunity for comment, is regulated by Section 90 sub 4. And I'll get to that in a moment, my lady. Lady, the sections implicated under PAJA, if I could just give you a list, are sections, they're all Section 6, so it's 2 small a Roman 1, 2 small b, 2 small d, 2 small e Roman 1, and 6F Roman 1. I'm going to leave your Ladyship to read them. I want to be brief and save time. Lady, filtering in the KwaZulu-Natal matter, there the amicus made submissions, as I've said, which are similar to that which we make here. And what the court found was essentially the respondents they knew precisely what the cause of action was. Here, my lady, we say the minister knew the cause of action for one, and he even went so far as to justify his decision. My lady, just as on a side note, Prayer 5 of the notice of motion would submit, the lady, that in these circumstances, that would not be a prayer you would consider granting relief under. That was the point I was making earlier. Your Ladyship will apply the law. In other words, you will first look at Section 90, ultimately, 90 sub 4, and you will decide, is it ambiguous, or is it in fact unequivocal? Or is it, and we say it is unequivocal. If your Ladyship has doubts, your Ladyship will then strive for an interpretation, a proper interpretation. If your Ladyship finds the one or the other, you come to a decision. If you find in favor of the applicant, your Ladyship interfere with the discretion of the minister can retake his decision once you've set it aside, if that's the route you've taken. The lady, the next point I will deal with is the question of whether it's premature or not.
Sorry, just repeat that. You broke off what? Just repeat that.
The next point I want to deal with is the question whether or not the application is premature or not.
I think, Mr. Willis, when you address me, try not to put your head down, because as soon as you put your head down, your voice tends to disappear and I tend to lose you.
Thank you, Milady. So, Milady, the second point I'll deal with is whether or not the application is premature or not. Milady, to answer that question in my submission, our submission, I have a junior here too, Mr. Monsignor, you must first identify the impugned decision, and your ladyship has already asked that pertinent question. Is the decision to publish an opportunity under the notice to comment, is that a decision? We say yes, it is. It's an administrative decision. It's derived clearly from section 90 sub 4. Milady, the decision, as your ladyship has repeatedly said this afternoon, is not about the promulgating of any regulations, whether in this draft form or some other, such as the minister has the right to do under section 90 sub 4B. So, Milady, we're impugning that decision, or the applicant is, and we support that application, Milady. So this is about procedural fairness. I refer back to the relevant section under section 6 of the budget.
I think the applicant said it's about the process, not about the decision.
Well,
the process which the applicant is challenging the process in that the time period allowed for comment is too short.
Well, I think, Milady, with respect, probably semantics, but if you look at their papers, what they are attacking is essentially a decision. I submit that's clear on their papers. But lady, I want to refer your ladyship to the matter of Airports Company. This is a matter which my learned friend, Mr. Butler, knows well. He was the succeeding party in this case. Airports Company South Africa, or AXA, as we all know, versus Imperial. That's this case, their car rental business. The citation is 2020, paragraph 4, brackets 4, South African Law Reports 17, and it's a decision of the Supreme Court of Appeal. I'd refer your ladyship there to paragraphs 60 to 18. There, my lady, you will find support for the following proposition. That case, Imperial were effectively excluded in the tender, even before they would tender, if I could put it as simply as that. The decision maker had no discretion to include them in the tender because the tender actually effectively locked them out. They were tendering again on the concession to run their rental cars from the airports. And there the argument was raised that the application was premature. In paragraph 18, I think it's the Justice Conan writing for the court, if I remember correctly, makes the point that, that argument doesn't hold water, and that it wasn't premature. Let me leave it there. Your ladyship will understand the point when you read the support in the authority. The third point, my lady, then to get to is the interpretation. Section does speak to procedure, but of course, the minister exercises a decision as to the procedure he's going to take. We know that section 94 sub A, sub 4 sub A, I want to go there quickly, my lady. We know that is a mandatory provision. The minister must publish in at least 3 months. However, in sub C, the minister is given a discretion. We submit that it is clear, it is unequivocal what the proper context and understanding of this qualification is. The minister may, if circumstances necessitate the immediate publication, there's no room for the situation that arises in this matter.
That's it. That's what he's saying. There's no room. Either publish immediately, you don't wait 30 days. It's immediate.
Publish that regulation without the consultation. In other words, without the opportunity to comment. So, my lady, it's clear and unequivocal. Mr. Butler will argue too, as is in the minister's papers, that it leads to an absurdity. You've heard Mr. Sibanda on that. I don't want to go beyond what the rules allow for me. But, my lady, if you do have a look at the criticisms in that affidavit, this case is not about, and nothing has been put up about this case as to how you should interpret the purpose of the Act, which is 45.1 in the answering affidavit. They say it's out of the context. The context has not been properly given to you in the paper. The applicant's heads actually deal fairly well with some of these aspects, my lady. And if you look at what subsection C is, it's initially a very wide berth given to the minister. So if you look at A and you look at C, it's a very wide berth. A is clear, peremptory, he must publish 3 months opportunity.
That's it.
Then he's given this wide berth that he doesn't even have to publish. He can give 0 times 0 opportunity. It's actually
there
0
it
opportunity.
is, Reg.
But look
right
at the condition.
0.
It must be a situation that necessitates immediate publication. He has no discretion between 90 days and no opportunity.
Exactly.
He only has one or the other, because the other, and he would have to justify the other, it would be extremely severe.
Either have
it's
it
not
or you
me
don't.
who's speaking. I don't know who's speaking.
So, ladies, please.
Don't worry, that was not me, because I'm not in there.
You have my submission.
I'm going to ask the parties again who is joining this link. If you're not addressing me, put off your mic.
There are some people,
I'm going
obviously,
to switch off
who are
everybody
in on the
and
original
kick everybody
link.
out, save for the legal representatives. It is
They are interfering
disturbing
there with the court at the
hearing
moment.
of this matter.
So don't
Your
worry,
right to
my
observe
speaking
is
here
not a right
cannot
to
be heard by
disturb
the
or
court.
interrupt. If you
Okay.
cannot adhere to this request, nobody will be allowed to join this link other than the legal representatives. Sorry, Mr. Willis, you may proceed.
Thank you, Milady. Milady, in other words, our submission is that there is no substance in paragraphs 45 and 46 set out in the answering affidavit. It does not hold water. There's no absurdity. It is clear. If your ladyship finds, as I've said, ladyship, let me say it's the end of the matter. It's unequivocal. And if your ladyship wants to test the equivalency of the subsections and venture into an interpretive exercise, which we submit really you shouldn't have to do, you ought to be able to decide on this, milady, with respect. Then in that event, milady, you ought, with respect, to still come back to what we submit, more particularly because this case is not about either the context, the purpose of the Act, no submission, nothing's been put up in relation to that, and especially not in the context of COVID, because that's what the minister says. He says this is for the sake of COVID-19. Well, your ladyship has no evidence, neither from the applicant and certainly not from the respondent,
Here we are.
that you can
Yes.
use to interpret
Exactly.
COVID within any context or with any purpose of the Act. And I think Mr. Sibanda was trying to make
Brilliant.
that to you
Brilliant.
in a very impassioned plea in another way. I'll leave that point there, milady. Milady, then the last point, milady, is that of the justification, as I've said to your ladyship, that clearly demonstrates the cause of action. And it brings one to this defense, reasons of a lacuna. Very, milady, that is raised in the papers at around, it starts off really around paragraph 11. The minister says that in the course of, he tells you when the fourth wave commenced. The fourth wave, we know, was starting, I think, November. I think he tells us November, and it's really by February that the numbers that dropped. In fact, in paragraph 11, he says in February 22, the highest day number of COVID-19 was. So, lady, it's there in March, the 14th of March, he makes this decision on his own version. He makes this decision. But milady, does it mean that if he made this decision only on the eve of the 3rd of May, when the 30-day residual regulations are going to finally fall away, bar the one which is named in the papers, does it mean that if he decided to publish on the 3rd of May, in a few weeks' time, that he could give no time? Because then he's allowed it to become urgent. No, milady. This minister, if he has a lacunae, if there's any degree of urgency, it is self-created. And if you read from paragraphs 11 to 13, that lays the foundation for that. And then when you go and have a look at his reasons in paragraph 20, what you realize, milady, in fact, is that, one, the cabinet knew and were preparing for the termination of this state of disaster. He knew long before that if he needed any regulations for an interim period in the future, that he had to do so timelessly. Respect, he didn't. And this argument of a lacunae in our respectful submission is a ruse. And the way that one tests that is, had he acted sooner, this is on his version, had he acted sooner, he would have been able to give more time. If he acted later, then entitled to give no time, or no opportunity. That's the correct phrase, no opportunity, no time, on the case. Those are our, we trust that have been of assistance to your ladyship. Unless your ladyship has any questions for me, I will proverbially take my seat.
Thank you, Mr. Willis. I will then just request that you put
submission
your
there,
mic
Reg.
and your camera.
Brilliant.
And Mr. Butler
Absolutely
then...
brilliant.
Yes, milady,
He's
would
really
you forgive
nailed
me saying the following? In the interest of time, milady, I haven't read the portions, and you'll understand that if I had more time, I would have. I'll leave that to you.
I appreciate that, Mr. Willis. What I can tell you is that I will go to the cases you've referred me to. I will read the paragraphs and I will read the sections that you have referred me to. I appreciate your understanding of the limited time that we have in the circumstances.
Thank you, Mother.
Thank you, Mr. Willis. Okay, Mr. Budlander.
Thank you, my lady. Just trying to adjust this light so I don't look quite as ghost-like. Good evening, my lady. Your
Good evening,
ladyship
Mr.
has
Budlander.
had a long day and has displayed, with respect, extraordinary patience in the face of all of us. I propose in the course of this address to deal with 4 issues. Firstly, I will deal with what the cause of action is. Secondly, I will deal with the purpose of public comment and the limitations on public comment. Thirdly, I will deal with the principles of interpretation as they apply to a statute. And fourthly, I will apply those principles to Section 90, which is the section that we are presently in. Now, my lady, and let me say, I will not address points which have not been pleaded and which are not properly before your ladyship. Because while your ladyship has, for understandable reasons, allowed those points to be canvassed, they are not pleaded and they are not properly before your ladyship. And I'll indicate some of what those are, but I won't address them. But can we just start with the cause of action? My lady, this is a case about 1 point and 1 point only. And I beg your ladyship's pardon. I will deal with those 4 points to demonstrate to your ladyship why there is no case. And then at the end, I will deal lastly with why, in any event, there is no urgency and this case is improperly brought. But I'm leaving that to the end, my lady, because I don't want your ladyship to feel that I'm running away from the merits. We say this is a case that is utterly without merit, and I want to demonstrate to that.
He sounds desperate.
Before getting to
he
the question
sounds
of
rather
merits
desperate.
and before getting to the question of urgency and inappropriate intervention. So let me start with the cause of action. This is a case about a point of law, a single point of law. It is a proposition that Section 90 sub 4 of the National Health Act only allows the minister 2 options: 3 months or more for public consultation on the one hand, or 0. And the applicant's case as brought said nothing in between. It's either 3 months or 0 or bust. And Mr. Willis, my learned friend Mr. Willis, with respect, has just endorsed that proposition. And I'm going to demonstrate that it is truly absurd as an interpretation, and it is at odds with the purpose of the statute, but that is their case, and I'll come back to it. So, my lady, this is not a case about whether the minister had good reasons for shortening the time frame. That is not the basis upon which it was brought, and it is not the basis upon which your ladyship can decide. It is not a case about whether the health regulations in their draft form are extraordinary, coercive, inappropriate, kill people, as was said by Mr. Sibanda. It's not about any of that. It is a case about one point and one point only, which is, does Section 90 produce this bifurcated approach of 3 months or 0 and nothing in between? That's the only point in the case. And with respect, my learned friend, Mr. Willis's attempt to broaden the case by referring to the KZN Joint Liaison Committee case is quite extraordinary, because that case reached exactly the opposite conclusion from what my learned friend suggests. Because, my lady, in that case, it is true that there was an amicus there who had sought to try and broaden the case that was before the court. What had happened there is that there were parties, that school governing bodies that had sued on the basis of a promise to pay school subsidies, and they had sued in contract. And the amicus, represented by Mr. Brickhill, came forward and said, well, you don't even have to worry about a contract. This is a legitimate expectation and it's subject to PAJA. And the question was, could the court deal with that? And the court answered that at paragraphs 31 to 33, Justice Cameron, where he said, but the form of the applicant's case is important. If enforcement is sought on the basis of administrative action, the proceedings should have been instituted under PAJA in the form of a review and within the 180-day period. None of this was done. Nor is this only a matter of form. The respondent's defense was that the undertaking could not be fulfilled because of a budgetary knock-on. The record of the budget allocation and decision-making would have been highly pertinent to a claim to enforce a promise at administrative law. It is not before us. Just let me pause there. If this was a case about whether the minister had good reasons, the minister would have had to put up a record and explain the stats, the concerns, the variance. None of that happened, because that wasn't the case. And so Justice Cameron concludes at paragraph 33, the result is that despite the amicus's argument to the contrary, it is not possible to consider the applicant's claim for the 2009 school year on the basis that the department breached the right to just administrative action. So I'm not quite sure what my learned friend seeks to make of that case. It is dead against him, because it says that you hold the case to the parties to the case as pleaded by the applicant, and that an amicus cannot change the cause of action.
Unfortunately, Mr. Budlander, I have not had regard recently to the case and I can't engage meaningfully. But as said to Mr. Willis, I will read the case.
Of course.
And I will go to the paragraphs to which you've referred me.
Not at all. Does your ladyship have a reference to the case?
I do. Mr. Willis has given it to me.
I have it as 2013, if it assists your ladyship.
I've got it to you. Just give me a second. I'm trying to work out my notes. Airports Company versus Imperial. Yes, I do have it. I've written it down.
Thank you.
Yeah, 2013, Volume 4, SA 266, decision of the Constitutional Court.
Exactly. Thank you, my lady. So that point on the cause of action, there is only one cause of action. It's about Section 90 and what it means, and that's the point of law, and that's it. Now we turn to the second point, my lady, against that back. And so I'm not going to deal with all the rest and the issues that my learned friends, both of them, seek to raise that go beyond that. Then if we can turn to the question of public comment, and I just want to say a word about public comment. There were portions of the address by our learned friend, Mr. Sibanda, which made it sound as though public comment was an end in and of itself. It's not an end in and of itself. Public comment is there to improve the decision-making, and it's there to allow people to feel that they've had a chance to have their say, and those are both incredibly valuable. But the reason I make that point is because what that means is there is no magic in 3 months as opposed to 2 months, as opposed to 1 month. Because if you allow people 1 month, then they can still influence the decision-making, and they can still feel that they've had their say. And indeed, just to give your ladyship an example, your ladyship will be aware that Section 4.1 of PAJA deals with the making of, deals with decisions about administrative action that affect the public, in other words, regulations and so on. And then it says that one of the things you can do is follow a notice and comment procedure, which is what's been done here. And then it cross-refers to the regs, which deal with that. And Regulation 18.2a of the regulations under PUDGA says that a notice of comment and period, a notice and comment period should allow for 30 days of publication. Now, I want to be clear, I'm not saying that that is the provision that applies here. I accept we're under the National Health Act. But what that demonstrates is that in the statute, which is designed to regulate administrative action, and the regulations that are designed to deal with notice and comment, a period of 3 months is not used. It's a period of 1 month. And what that shows is there is no magic in 3 months versus 1 month. And to say that if it's 1 month instead of 3 months, there's irreparable harm, people will suffer, all the rest, it just doesn't follow, with great respect. Public comment is about giving people as much time as they can to comment within the practical constraints that society operates in. And that's what I'm going to come back to as being the purpose of Section 90. Could I then turn to the third question? And the third question is the principles of interpretation. And I need to make 2 points. We have set out those principles at great length for your ladyship in the heads. Your ladyship will have seen them, and we are not going to detain your ladyship by reading them all. They are set out in paragraphs 50 through to 57 of our heads. There are only 2 answers to those. Our learned friend, Mr. Sibanda, says the courts have been inconsistent in the way they've dealt with Endumeni. With great respect, that's not true. The courts have consistently embraced Endumeni. They have embraced it for many years. Of course, sometimes they sometimes they give different glosses here and there, but the principle that context, purpose, and text are all considered together at the beginning in a unitary exercise, the courts have said again and again and again and again, hundreds of times now, following Endumeni. So there's no inconsistency there, and that point can be put to one side. That leaves my learned friend, Mr. Willis's point, because what he argued, with respect, my lady, is he argued that the wording of Section 90, I think his word was dictated a particular result.
I think if I understand his argument correctly, that I only need to go to the interpretive principles if the wording itself is unclear or ambiguous.
That is, then your ladyship and I understood the argument exactly the same way. My lady, that was our law 30 years ago. It is no longer our law. And the fact that it is no longer our law is made clear by the cases that we have cited in paragraphs 51 and following. We cited for you Thoroughbred Breeders, which was decided 20 years ago in 2001, where the court said the days are long past when blinkered peering at an isolated provision in a statute was thought to be the only legitimate technique in interpreting it if it seemed on its face to have a readily discernible meaning. That is directly at odds with the argument that my learned friend Mr. Willis advanced. And then when you read Endumeni, and I will read you a passage from Endumeni that is not quoted in the heads, but which puts the point rather well. In Endumeni, at paragraph 19, Justice Wallace said, he speaks about the emerging trend in statutory construction, and he says that the emerging trend is to consider context and language together from the outset. And then he quotes Anthony Mason, CJ, as saying, problems of legal interpretation are not solved satisfactorily by ritual incantations which emphasize the clarity of meaning when words are viewed in isolation, divorced from their context. The modern approach to interpretation insists that context be considered in the first instance, especially in the case of general words, and not merely at some later stage when ambiguity might be thought to arise. That is the statement of Sir Anthony Mason, CJ, embraced by Mr. Justice Wallace. And then when you go on, and I will not belabor it by reading it, but when you go on to read Endumeni at a later stage, paragraph 25 of the judgment, It's exactly the same point, which is he addresses this idea that sometimes the language seems clear and admits of little ambiguity, and courts say they're just following the ordinary grammatical rules. And he says that's a misnomer, and it's a product of when language was thought to have one meaning only, and he says that's absolutely wrong in our law. So the center point of my learned friend Mr. Willis's argument that you only go to interpretive principles when there's ambiguity is just wrong. It's been wrong for 20 years, and it's been wrong since the Ndomeni case. My lady, against the backdrop of the principles, can I turn to deal with this provision and deal with why the interpretation advanced? Can I call it the two options only interpretation, 3 months or zero or none, is simply wrong? And let me say, firstly, my lady, that I must make a concession, which is I accept that when the provision is read in isolation, when you read it outside its context, when you read it outside the Constitution and outside of the purpose, it does appear to say 0 or 3 months. That is the can I call it the first read that one gets?
The plain reading of the terms.
Even the plain reading, exactly. The blinkered read, in the words of thoroughbred readers, if you engage in a blinkered hearing at the provision, that is what you get. But of course, we know, for all the reasons I've given, that that's no longer the appropriate approach. And for the following 4 reasons, it cannot be right. The first reason, my lady, is that it must be read in context. And so you can't read 94C without reading 94A. And when you read them together, it is clear in my submission that the context is that they are postulating 2 ends of an opposite spectrum. I beg your pardon, 2 opposite ends of a spectrum. On the one hand, they are postulating at least 3 months as a default position. And on the other hand, they are postulating no comment at all at the other end of the spectrum. So when you read them...
Sorry, Mr. Budlander. When Mr. Sibanda was arguing, he said if one does have regard to the context of the act as a whole,
yes,
there's no... It's still the same. Sorry, my phone went off. It seems as if one, and he took us to the preamble and he took us to the bullet points of the act. And he said, even if you have regard to that, the context and the preamble of the act and the objective of the act can never be used to interpret section 94A and 94, and to a lesser extent 94C, to provide the respondent with some leeway to create a third option between 90 days and 0.
Yes, so I'm going to come to that in just one moment. The context that I would just emphasize before I get there, if I may, is I would emphasize 2 elements of the context. The first is that you've got to read 94C with 94A. You can't read them apart from each other. You've got to see them as the opposite ends of a spectrum. But the second point about the context is that you must look at the issues on which regulations can be made. And when you look at section 90 sub 1, you will see that there is a vast array of matters. Some of them will be urgent, some of them will be less urgent, some of them will be critical, some of them will be less critical. But they range on everything from norms and standards for national health systems, which you would expect would be a long process, to notifiable medical conditions, which might be very urgent, to emergency medical services, to you name it, they are there. My point is, when you look at 90 sub 1 and you see the number of different things around which regulations can be made and to which 90 sub 4 applies, it's clear that you need flexibility, is my submission. So that's the first submission, is context. But let me deal, my lady, with the point that you put to me quite properly about purpose. And I, with respect, simply do not agree that the purpose is at odds with the interpretation we've advanced. We argue exactly the opposite, and let me explain why to your ladyship. Could I begin with the objects of the act? Because that, of course, is the purpose. And when you read section 2, it says, the objects of this act are to regulate national health and provide uniformity in respect of health services by A, establishing a national health system, etc., etc. B, setting out the rights and duties of healthcare providers, etc. C, protecting, respecting, promoting, and fulfilling the rights of 1, the people of South Africa to the progressive realization of the constitutional right of access to healthcare. 2, the people of South Africa to an environment that is not harmful to their health. 3, children to basic nutrition and health. 4, vulnerable groups such as women, children, older persons, and persons with disability. So the fundamental aim of the Act is healthcare. It's getting healthcare right. But obviously, the Act recognizes that you need to do so in a way that allows for public comment. But let me ask your ladyship this question, if I may, rhetorically. Suppose, and you must ask it on this supposition, suppose that there's a set of regulations which are urgent. They are more urgent than the 3 months that would ordinarily be allowed. It would plainly, and yet there is enough time to receive some public comment, and we're told by the Constitutional Court that public comment improves decision making. Which interpretation better promotes the object of promoting health rights in South Africa? The interpretation I advance, which says that the minister can then still consult, still get the benefit of public input, but do so for a month or 2 and still enact the regulations in time to fix the problem. That's my interpretation. Or the interpretation my learned friends advance, which is to say the minister only has 2 options, 3 months or bust. And what that means is if for whatever reason he doesn't have 3 months because a virus has arrived or because there's a new technology or an urgent situation, he then can't consult at all. And the people of South Africa have no right to say anything at all. With respect, their interpretation is plainly at odds with the object, because my interpretation, the one my client advances, plainly allows the minister to promote healthcare, but in doing so balance it with the need to get public input. And as I've said, that promotes that promotes better decision making. And so whether you look at it that way, or whether you look at the preamble, which speaks about socioeconomic justice, the need to heal divisions, the need to improve the quality of life, speaks about 27.2, 28.1, uniting various systems, etc., and speaks about a spirit of cooperation between everyone. All of that, my lady, is perfectly consistent with what I've suggested, which is 3 months as a default, but a power on the minister to reduce that where necessary, all the way down to 0, but only down to 0 where necessary. If the minister doesn't need to enact immediately, the minister must still do the best he can with public consultation. And so we submit with great respect that the purpose is plainly on the side of the submission that we're advancing on behalf of the minister. So that's the second reason. The third reason, my lady, and it was not addressed at all by my learned friends, is the need to render it consistent with the Constitution. Now, the Constitution speaks about public participation. It does so, I think my learned friend, Mr. Sibanda, said in some of the sections dealing with Parliament. But the Constitutional Court has spoken, my lady, about that, and we've given your ladyship the case about SABC versus NDPP, which is actually a freedom of expression case. It's about the SABC's duties. But there the Con Court says that public participation on a continuous basis provides vitality to democracy, and it reflects the foundational principle of democratic governance, which ensures accountability, responsiveness, and openness. So public participation is good for the Constitution. It is critical. It is part of the Constitution. So now let me ask the question again. Let us say and assume that the minister has something that is too urgent to wait 3 months. On the other side's interpretation, that means the minister may not engage in any public consultation, not for a week, not for a month, and not for a month and a half. He must enact without hearing the public at all. On the minister's interpretation, he must still engage in public consultation. He can't do 3 months because of exigent circumstances, but he can reduce it. Which interpretation, I would ask, promotes better the principles of the Constitution, which we know include public participation to provide vitality to democracy? Well, self-evidently, my lady, the interpretation I'm advancing, or the minister is advancing, is better as a system for ensuring accountability, responsiveness, and openness, because the other side's interpretation increases the odds. It increases the odds that health regulations will be enacted without hearing from the public at all. And maybe we need to call a spade a spade. Their interpretation substantially increases the odds that severe health regulations will be enacted without hearing the public at all. How can that ever be, I would ask, consonant with the purposes of the Act? How can that ever be consonant with the purposes of the Constitution? And that leads me to the fourth point about absurdity and unbusinesslike results. And my learned friend, Mr. Sibanda, and indeed Mr. Willis, professed to not understand how it could be absurd. Well, my lady, let me demonstrate the absolute absurdity of this. Suppose that for a given reason, the minister knows he needs to enact regulations, let's say, by the 1st of May. But for some reason, there's a problem, there's a this, there's a that. The regulations are not published for public comment 3 months in advance. They are only published for public comment to allow 2.5 months in advance. Now, on the other side's version, that means he must dispense with public consultation completely. Just because he can't do 3 months, he must get rid of any public consultation. It is a patently absurd result to say that the minister wants to put the regs out for public consultation. The public want to receive the regs for public consultation and want to make submissions, and yet the Act precludes the minister from doing so. That is the height of absurdity, and yet that is exactly the consequence of the argument, of the interpretive argument advanced by our learned friends. So we submit with great respect that for all 4 reasons, for reasons of context, for reasons of purpose, for reasons of constitutional compliance, and for reasons of avoiding absurdity, the interpretation which is advanced by our learned friends is simply hopeless, and that the interpretation we advance is plainly correct. And once that is so, my lady, that ought to be the end of the case. That leaves, so my lady, if that's so, then your ladyship can simply decide the case on that basis, and your ladyship does not need to deal with questions of urgency or intervention. But let me deal with those 2 questions briefly to round up. My lady, on the question of urgency, we have heard my learned friend's reference to East Rock Trading, the judgment of Mr. Justice Notche, and that's the one he relied on. That is a judgment which says that the test for urgency is whether you can get substantial redress in due course. That's the test. Well, my lady, assume that the regs are enacted in their present form. There is nothing at all to stop the applicant bringing an urgent application for interim relief pending review. The fact that that application would be a poor one, just like this application is a poor one, doesn't change it. The applicant would be able to bring that application, and so why would he not be able to obtain substantial relief in due course? He'll be able
my understanding, Mr. Budlinder, and I'm sure Mr. Sibanda will correct me in reply if I'm incorrect, is that it's not the outcome which they would be able to obtain substantial relief in, but by the process being defective. Once that process is finalized, the right to participate in that process is gone, and they won't be able to obtain substantial relief to participate in a legitimate process.
Thank you, my lady. I'm very grateful for your ladyship clarifying it. But if that is the proposition, it is hopelessly wrong for this reason. Assume that the regulations come out on the 15th of May, and assume that an urgent review is launched and that the court sets aside the regulations for this reason on the 22nd of May. What would be the remedy? The remedy would be to direct the minister to engage in a further public consultation period of 3 months. And so they would get their opportunity to participate. The remedy would allow them to participate for the very 3 months before the regulations came into force. And that's why I say, my lady, there's no magic in public participation itself. Public participation is valuable because it allows people to influence the process. It signals respect for people's dignity. But the point is that if it is set aside, that will be reviewed, that will be allowed, because the court will direct that it be fixed. And the court will say to the minister, you didn't have a lawful basis for doing what you did. Go and do it for 3 months. Now, of course, we know that that wouldn't happen because this proposition is wrong as a matter of law. But if it were right as a matter of law, they will have their remedy there. So there is no urgency, my lady. But even if there were urgency, the urgency is entirely self-created. Your ladyship has not been told at all on why the application was brought when it was. And with great respect, there was no ruling on urgency last time, and my learned friend, Ms. Mayosi, has confirmed to me, and I wasn't involved last time, that her understanding was that there was no ruling on urgency and that the draft order was approved by my learned friend, Mr. Sibanda. And so the question of urgency continues to loom large, and with respect on that basis alone, the application should fail. But your ladyship may wish, having heard the full argument, to simply express herself on the merits of the point. Because, as I've demonstrated, it really is quite a crisp point and one on which the argument on the other side is hopeless. That leaves only one last issue, my lady, and that is the question of prematurity. And we say that it's premature because no decision has been made to enact the regulations. And so therefore we say that the proper time to bring the application is when the regulations are made, if any, because we don't know what the regulations are going to be and we don't know when they'll be made. But let me say, my lady, there is, my learned friend, Mr. Willis, calls in aid the AXA case, the AXA Imperial case. But there's a difference between the cases. AXA versus AXA Imperial was a case about BEE, and as he points out, I was in it. But AXA Imperial was a case about BEE requirements. And what had happened was that AXA had said, in order to tender, you have to be 30% black BEE, 30% black owned, otherwise we'll disqualify you. So Imperial brings the case and says, we don't even want to go through the tender because the prejudice is obvious. We are obviously going to be disqualified. And so therefore it's inevitable and therefore it's not premature. And the court upholds that. This case is exactly the opposite because your ladyship is sitting in a position where it's not at all inevitable that there will be prejudice. Your ladyship does not know what regulations will be enacted. Your ladyship does not know what the terms of those regulations will be, when they will be enacted. And so it's quite possible that a narrow set of regulations will be enacted in order to deal with all the public comments, etc. We simply don't know. But so there is no inevitable unlawfulness in this case. Quite the contrary. Everything will depend on what is done and what is ultimately the reason. He misses the point. And so again, this is quite unlike the AXA Imperial case. It's quite the opposite.
It's not about the regulations.
We submit,
he's missing the point.
Law. The legal point, let me go back. The cause of action is single. It's a point of law. The point of law is bad for all of the reasons I've articulated. And the case should be dismissed on that basis alone. But in any event, the case has been brought inappropriately without an urgent basis and on a self-created urgency basis if there is urgency. And in any event, the case has been brought prematurely and we've pointed your ladyship to all of the authorities in that regard. So for all of those reasons, we would ask that your ladyship dismiss the application and that will enable the process to follow the ordinary course. And we do not seek an order for costs, despite the quite extraordinary way in which this case has been brought. We accept that BioWatch applies.
Thank you, Mr. Budlender.
So, Milady, might I prevail on your ladyship just to correct one aspect I maybe did myself and my client a disservice in rushing. I just want to make clear the following. I hear what Mr. Budlender says about the law 20 years and 30 years and then and Ndimeni. We don't agree with his submissions of Ndimeni, but my submission is in the context of this case, in the context of my submissions to you, that context and purpose are not an issue because they're not properly raised. And if your ladyship goes to paragraph 64 of our learned friend's heads, we understand there that they were not relying on purpose, but on paragraph 64. But there's another case that can be of assistance to ladyship. It's a new case, recently come out. It's the matter of natural health products versus the minister. And if I could give you this,
Mr. Willis, I'm going to allow you to give me the citation, and then I'm going to not allow you to address me further, because this in itself is...
And Mr. Budlender can respond if he needs to. But it's cited as case number 256/2021.
Here we are.
Square brackets 2022.
Natural health products versus the Minister of Health. Paragraph 27.
It's 49, and it's April. It's a decision that came out now in April 2022. The ladyship will find assistance in that case on these issues. Thank you.
Thank you, Mr. Willis.
I've been indebted to your ladyship, and of course, Mr. Budlender is entitled to some response should he wish. Thank you.
Thank you. Mr. Budlender, do you wish to respond to Mr. Willis before I go back to Mr. Sibanda?
My lady, just one point. My learned friend, Mr. Willis, is out of luck. My wife argued that case, my lady, and so I'm familiar with the case. And the one thing that case does not do is suggest that you can ignore a contextual interpretation. If your ladyship looks at paragraph 20, what it says is, it was rightly common cause between the parties that on a sensible contextual interpretation of the definition things are limited to therapeutic or medicinal purposes. So it embraces the idea of a contextual definition. And the only other point I would make to your ladyship, because my learned friend, Mr. Willis, seems somewhat confused about the argument we're making, we don't only rely on context or only on purpose. We rely on all. We rely on context, purpose, 39.2, and the need to avoid absurdity. Each of those is a self-standing basis to reject the interpretation that's been advanced. Thank you, my lady.
Thank you, Mr. Patlander. Mr. Sibanda? Mr. Sibanda, your reply?
Most indebted, your ladyship.
Mr. Sibanda, I am going to ask you, since it's reply, to hold your reply to half an hour.
I'm sure I'll be much less than that, your ladyship. Your ladyship, I really don't, excuse me, I really don't have much to say as regards what my learned friend, Mr. Willis, raised. And definitely I will say that the issue at hand is really about the process. And I agree with him that it's a question of semantics, really, when you talk about process and decision. It's a decision to abide by a particular process, which process is governed by the Act. And we're saying that it is ultra vires, the Act of Parliament, the process that has been engaged upon. As regards my learned friend, Mr. Patlander, firstly, in talking about the cause of action, he tells us about what the case is not about. And yeah, definitely, it's not a case about whether there is a good reason or not, and it's not whether the draft regulations are extraordinary or not. He captures it properly when he says that the matter at hand is whether the law that is being applied, which is Section 94, allows for two options or not. And the issue, therefore, when we're looking at the cause of action, in looking at the aspect of the ultra vires element of the action of the minister, my learned friend, Mr. Willis, quoted from the Minister of Health and another versus Alliance for National Health, which is already in our additional heads under paragraph 12, 13, and 14. The most important aspect being that the court made it clear, and in that case, it was a case also dealing with regulations, in as much as these particular regulations were speaking to a different
Here it is,
topic,
paragraph
but the minister
27.
is the same. So if the regulations or part thereof are beyond the powers of the minister, they are invalid under the Constitution. And so it's authority for the fact that where the minister in the whole process of regulations acts outside his powers, those powers are invalid. And in this particular case, the minister has acted outside his powers by giving himself a non-existent 30 days. And therefore, it's ultra vires. And also, to add emphasis, at the aspect I'm talking to now is at paragraph 13. At paragraph 27, amongst the issues that the court raises is
27,
that,
Mr. Sibanda, 27 of your additional heads or 27 of the case?
I apologize, your ladyship. That was definitely ambiguous. Paragraph 27 of the case. Thank you, your ladyship. Where the court says about the minister, it not only introduced the word maladies, but failed to give due recognition to subpara A2 of the definition of medicine. So the court took exception to the fact that minister can simply introduce out of nowhere words and incorporate them into legislation with no basis for them, because there was nothing that defined them. So now we are saying in this particular instance, the respondent has again violated that principle of failing to apply the aspects related to the provisions of a subparagraph. I notice very, very clearly that my learned friend, Mr. Padlender, in advancing his arguments, he's talking about hypotheticals. He's just giving us hypothetical situations which have nothing to do with this case. And even if he goes to section 91 and lists the different conditions or situations under which the respondent may pass regulations, some may be serious, some may not be serious, but he does not speak to the ones that the minister has passed regulations on. Where do they fit within his analysis of his hypothetical situation? Which ones, according to the National Health Act, according to Mr. Padlender, are very, very urgent? Which ones are not very urgent? Which ones are stuck somewhere in between? And even if indeed there were some that are stuck in between, if we were to agree with his line of reasoning, not once, Your Ladyship, has he pointed us to any part of the National Health Act that justifies the provision of 30 days. In as much as he'll talk about PAJA and how PAJA talks to 30 days, I love that aspect actually. The critical aspect being that the PAJA recognized that legislation can pass for 30 days. But with this particular one, the health one, in realization of the fact that it cannot be generalized on 30 days, the legislature made it a point that it gives a clear cutoff period. And the most important thing about what we're saying, Your Ladyship, is that the law says at least. It does not even say it should be 90 days. It does not say it should be 3 months. It says the minimum possible time that should be given the people is 3 months.
At least
and I agree fully with Mr. Padlender that in looking at the interpretation of these particular sections, we must look again back at the preamble, promoting the spirit of cooperation and shared responsibility amongst the public. How, I ask Your Ladyship, does taking away people's rights to participate in a democratic process for at least 30 months promote a spirit of cooperation between government and the people? How does it promote shared responsibility amongst the people? I submit that it doesn't. And one of the things I would like to emphasize, Your Ladyship, I really enjoyed listening to Mr. Padlender about public participation. And this case is not about public participation. We're not here asking the court to give us an interpretation of public participation. We are here in this court saying, according to Section 94A of the National Health Act, the people of South Africa deserve a minimum of 3 months. And it's interesting that he no longer talks to the lacuna that they spoke about.
Yeah, he's gone dead quiet on it. Doesn't address it in his argument.
Ladyship. And on prematurity, again, he wants to push us on prematurity as regards the regulations. But that
the case is not about regulations.
And thank you for correcting the position as regards what we are saying as regards the time factor, because that is where our issue lies, on the time element, that if the people lose this particular aspect now, then the people have lost. And it's important for the court to compel the respondent to comply by the law. It's 90 days according to 94A, or it's immediate, it's at least 3 months according to 94A, or it's no consultation.
Or nothing.
According to 94C. Anything in between not once
Doesn't
did Mr.
exist. It's
Padlenda
not
even
relevant.
give us any particular interpretation,
Nothing in the law
or
about
rather
where it is.
section that we can interpret to say there is a range and the minister has that discretion. He has no discretion. And
Boom,
yes,
home run.
this is what we are saying. If there is a situation that deserves to be immediately attended to, the minister may invoke the provisions of Section 94C. And in a situation where there is no necessity to invoke Section 94C, then he is bound by Section 94A. He cannot willy-nilly change and decide that today is 2 days, tomorrow it's a week, next week it's a month.
Yeah, show us where in the law does it say 30 days?
Business-like results. Because then we don't have a precedent. Any minister can just decide, oh, wow, I think coughing is a serious notifiable medical condition, and do it within 2 weeks and say, let's consult 2 weeks and that's it. But where does he get it from? Nowhere. But if he says, I'm applying 94C, he's at liberty to do that, and we challenge that particular aspect. But otherwise, from what has been submitted, Your Ladyship, I'm afraid to say the court has been presented with nothing, absolutely nothing, which justifies why it is that the minister may be allowed by this court to give us a situation where the public can only be consulted for 30 days and be denied their right to 90 days. And Your Ladyship, in closing, I basically would love to implore the Honorable Court to exercise its authority to take a decision in keeping with the legislation. And I'm interested as well in that when Mr. Padlenda was talking to Ndumeni case, the inconsistencies I'm talking about, I'm literally quoting one paragraph in and the next, where the Constitutional Court itself has failed to apply. I fully agree. They have endorsed it. They have said it. But the question is, have they applied it? It's not enough to argue and say that this court has endorsed a particular decision. Over and above the question of endorsement, the question that we have to ask ourselves, after endorsing, then what? If the then what is not answered by
it's not applied, it's not applied,
then it means Ndumeni endorsements are not critical. Ndumeni is an important case, I submit, but the situation as we speak is that the Ndumeni...
You accept, Mr. Sibanda, that I am bound by decisions of the SCA and the Constitutional Court?
Absolutely, Your Ladyship. And this is why I'm raising it as a point that in Your Ladyship being bound by these decisions, Your Ladyship must also pay attention, so I humbly implore, to the fact that there are cases where the Constitutional Court endorses a decision, but then goes and does something else. If, with your indulgence, Your Ladyship, simply by pure reference.
I'm going to allow you to give me case references, Mr. Sibanda, but I'm not going to allow you to read from the cases.
I'm not going to read anything.
I'm happy for you to give me references.
It's actually it's an article that the Ladyship will find very interesting. The Life and Times of Textualism in South Africa, square brackets 2019 PER 65. A very,
Mr. Sibanda, because it's an article, can I ask that you make a copy available?
I'll definitely do that, Your Ladyship.
Would you be able to do so during the course of the evening or tomorrow, given the urgency of the matter? And if you want me to have regard to it, you're going to need to get it to me urgently.
I'll get it to Your Ladyship this evening. I'll make sure that Your Ladyship gets it this evening. That's a very critical case in as far as a deep analysis of Ndumeni by Advocate Kessler Perumal Sami. Yes, thank you, Your Ladyship. That's all I wanted to say. Oh, sorry, Your Ladyship. Sure. Thank you, Your Ladyship. Mr. Pillay was just bringing to my attention that in as much as my learned friend, Advocate Badlenda, did raise the issues that he raised and failed to mention any time frame, he also did not address the court on the aspect raised about notice number 46048 and some of the inconsistencies that have already been put before the court. He just let it fly and gave the hypotheticals that he gave, and therefore
So
even did not respond to the supplementary affidavit as regards the deleted emails, etc., etc. That in closing,
I think that is raised. I think the supplementary affidavit, Mr. Sibanda, is raised either in the answering affidavit or in the heads, where it's said that it's based on hearsay evidence, and it is explained. And furthermore, that no application was made for the court to receive the supplementary founding affidavit.
Indeed, Your Ladyship, which aspect even the legal team that was here the last time never challenged it. Anyways, no, that's fine, Your Ladyship. I think
exactly.
Mr. Sibanda, it's not 100% correct that the legal team never challenged it. When I put it to Ms. Mayosi what the attitude towards the supplementary affidavit is, she said their position towards the supplementary affidavit is the same towards the main application, in that they've not had a proper opportunity to take instructions pertaining thereto, and therefore she could not address me on it. That is not necessarily not challenging it. It's saying they never had an opportunity. It makes no difference.
It doesn't advance their case.
Yeah. To it.
That aspect is noted, Your Ladyship, and besides, the admission or non-admission of the supplementary affidavit does not detract from the applicant's case. Those are my submissions, Your Ladyship. Unless if I can be of any further assistance to the Honourable Court, those are my submissions.
No, thank you very much, Mr. Sibanda. I have to thank all the parties for their submissions and the engagement with the court, albeit on short notice that some parties joined us. Thank you to Mr. McDonald and Mr. Williams and Ms. Schroeder as well for the participation, albeit to a limited extent in this matter. The court is indebted to heads of argument where some have been filed. I am grateful for the amicus' submissions. I am not going to give judgment immediately. I'm going to reserve judgment. I will notify the parties, or judgment will be delivered electronically and the parties will be notified thereof. I am conscious that the order that was taken postponing the matter to today gave an undertaking to the 3rd, which is next week, Tuesday. I will endeavour to get something out to the parties before then, whether it be an order or whether it be an order with abbreviated reasons. Thank you. Court will then adjourn. Judgment reserved.
Thank you. Thank you very much, my lady. That's cool, please.
Thank you.
As your ladyship pleases, my lady.
That's it. Yep. So we'll get judgment later on. The court will not decide today. So there you have it. Everything has been submitted now. And what is that? People are asking if you can whisper as they can't hear. If I can whisper, well, I can speak. Well, let me know if you can hear me still. I suspect you can hear. I just check with my IT guy whether the sound and everything is all right. Let me just check it on here. Yeah. The sound looks brilliant. Yeah, I almost boxed someone out of your behalf just now. Okay. All right. No, it's showing live. Okay. Brilliant. Well, that was the court matter today. And as you can see, submissions had been made, and the government's case, it just doesn't wash. They hadn't touched on everything at all. They contradict themselves. in their own, and then he talks about public consultation and participation as a matter of importance, but he can't seem to see the very point we're making about why it is necessary for the public to participate. Well, with that, my friend, we'll leave it up to the judge now to go and deliberate on this case. And as soon as we get an order delivered to us electronically, we're going to be out on the blowers and tell everybody about that. And we may come out soon and perhaps just give a summary of case to it. People who've not been able to participate in the hearing. Thank you very much for those of you who stayed in until the end. Stay tuned. And I'm just going to make sure that IT department shuts this feed down for us. Nonetheless, it will stay here for people who want to come and watch the whole proceedings afterwards. Other than that, we aim to provide a summary at some point about the case, both on the website, and maybe we'll also do a live. Thank you very much. Just send a message. Here we are. Hey, brilliant.